Okay. In accordance with Section 5 of the Open Public Meetings Act, Chapter 231, Public Law 1975, be advised that a notice of this meeting was made by posting on the bulletin board, town hall, and mailing to the officially designated newspapers. A list of the meeting dates annually, including indicating that this meeting would take place at Town Hall, 7 p.m. on Monday, June 5th, 2023.
Ashley Abingdor. Here. Chandra Harjani.
Here.
Amy Lawrence. Here. Gary Rosen.
Here.
Regina Truitt.
Here.
Joseph Caulfield.
Here.
Vice Chair Jessica Black.
Here.
Chair Peggy Carter.
Here. Good evening, folks. We have a busy docket tonight. We're going to keep rolling through this so we can get everything done, as we don't want to carry more cases forward. So I ask everyone to be prompt and get your testimony in and get going. If there's anyone on a case here tonight that would like to speak, we'll give you ample time to voice your opinion, whether in a statement or in the form of questions. We're going to start this evening with approval of minutes, first being 4/17/23. Any corrections or changes to those minutes? Folks, if you could turn your mics on. I think John did it. Any corrections or changes to those minutes? Who's eligible to vote on that?
Ashley, Amy, Gary, Regina, Joe.
Would one of the people named make a motion?
I'll move approval of minutes from 4/17/23.
A second?
I'll second.
All those in favor?
Aye.
Anyone opposed? Next, we have approval of minutes of 5/1/23.
Eligible are Joseph Caulfield, Chandra, Amy, Gary, Regina, Jessica.
Any corrections or changes to those? If not, can I have a motion to approve those minutes?
I'll move approval of minutes from 5/1/23.
A second?
I can second.
Thank you. All those in favor?
Aye.
Anyone opposed? Next, we have two memorializations. First one is calendar 39/21/23, Shakib Anwar at 1060 Morris Turnpike in Short Hills. Any corrections or changes to that memorialization? Who do we have eligible for to vote?
Chandra, Amy, Gary, Regina, Joe, Jessica.
If there are no corrections or changes, can I have a motion on calendar 39/21/23?
I move to approve the memorialization calendar number 39/21/23.
A second?
I'll second.
Chandra Harjani.
Yes.
Amy Lawrence. Yes. Gary Rosen.
Yes.
Regina Truitt.
Yes.
Joseph Caulfield.
Yes.
Jessica Black.
Yes.
Next up, we have calendar 39/22/23, Tom Bayo, 1 Nottingham Road in Short Hills. Any corrections or changes?
This is the one.
Yeah.
Calendar 39/22/23, 1 Nottingham Road. There's a question as to this resolution. It's still under review, so we're going to carry this resolution to the next hearing.
Thank you very much. So we will not be voting on that resolution this evening. Next, we have our first application. This is an application carried from 5/15/23, calendar 39/07/22, and Miller G. Plowman, located at 79 Chestnut Street in Milburn. The party come forward regarding that application.
Announce the timer.
I'm sorry.
That's later in the agenda. 39/14. They carried.
Oh, they're being carried again. Okay. Oh, so real quickly, 39/14/23 at 86 Slope Drive, David and Lori Schlanger. If you're here for that case this evening, you will be carried to 8/7/23. Okay. So if you're here on that case, it will not be heard this evening. So congratulations, you get to go home. So moving back, we have calendar 38/78/22. 39/07/22, and Miller G. Plowman.
Chairman, members of the board, good evening. For the record, Daniel Steinhagen from BD Pettivano on behalf of the applicants. Before we start, there's two things that I need to correct from the last meeting. I think we were here back in March. I had indicated, based on what I thought was on the list, that the property owner adjacent to us got notice. They did not. We ended up sending them a letter. We had relied on the list, and I know that they're here tonight, and they're prepared to speak tonight. So I just wanted to make sure that everybody understood that I had made a mistake. I thought that they were on the list. They were not. The second thing was there was a question asked of me, the volume of the device, and we've determined, and we may hear about it later this evening, that it's not, I had said it was under the state noise code. It's actually substantially in excess of the state noise code. State noise code doesn't apply to residential activity, but in terms of volume, and I do have evidence from that, if, should we get there. Just want to make sure, since I know there was some new faces or faces that weren't here back in March, that everybody who's here, who's going to participate, is eligible to vote, just so we have that.
Can we confirm that?
She,
You were here at the March.
I think you were here.
You should
I
say.
Yeah.
was here.
I wasn't here, I've listened to the YouTube recording, so.
I was not here either, I think.
But everyone has listened to it.
Have you listened to the YouTube or no, or watched the YouTube on this case?
I did not.
Okay,
I didn't hear.
Yeah. Here.
so you.
No, I'm fine. I
Yeah,
just,
you're full board, so.
no, okay, just, there needs to be I'm not saying it needs to be now, but we need to get certifications in the file.
Absolutely.
Okay.
Yeah, we'll have that folks on.
So when we ended at the, I think it was late on the 20th, Mr. Rosen had indicated that he needed some more time to think about it. Since that time, we've gotten into contact with the neighbor. I don't know if they want to speak or not, but the witnesses who testified, if they want to ask them questions, are here tonight if they want to.
And we'll give them the opportunity to.
Yeah, absolutely. But I know we closed. It's up to the board as to how they want to proceed.
Yeah, and if that's the case, then we'll certainly give them, based on the lack of notice, the ability to
Absolutely.
ask questions
Sure.
and make comment.
We may have some rebuttal information depending on what comes out, but
Sure.
we'll deal with it when it comes.
Any further testimony that you would like to?
Not on direct. I'm anticipating some, but it's going to be based on what happens, subject to the neighbor's presentation and questions.
Sure. Very well.
Thank you.
So with that, are there any comments at this point from the audience?
Over the neighbors.
Oh, would you like to speak?
Yeah, I think.
So for- let's first start with, are both of you going to speak or just one of you?
Yeah.
You're both going to speak?
Yeah.
Come on up. We're going to have to swear you in and get your information. Go ahead.
Sure.
Good.
If you would both just raise your right hand, please. You swear from the testimony about to give in tonight's proceeding, give the truth, the whole truth, and nothing but the truth.
Yes.
Your names and address for the record, please. Spell your names.
Edward Cochran, 445
Would you
Wembley
spell your last name
COCK-RAM,
and your address?
445 Wembley.
Yeah, it's a.
So it's Edward Cochran from 445 Wyoming Avenue.
Gabrielle Cockrum, 445 Wyoming Avenue, Milford, New Jersey.
Please proceed.
Sure. I think we're mainly here today because we're a little bit concerned about the tone from the last meeting, especially some references to callers and calling child services, which I found pretty disturbing. But otherwise, we just want to be clear for the record that we didn't put this up as a form of harassment. It was entertaining. We bought it for Halloween decoration, but it was entertaining for our kids. So we left it up in the yard. Can appreciate that it was probably on and off for a year or so. My wife's got some numbers on usage. She went back for the cameras to look at it. But otherwise, once it was clear the level of annoyance it caused, we've taken it down. It's not in the backyard at all anymore. We probably would look to put it back up for decorations around holidays, but that's about it. Do you want to get some?
Okay, sure. All right, so I actually prepared some notes, so I'm just going to read off of this. All right, hi, I'm Gabrielle Cockrum. I live at 445 Wyoming Avenue, and I'm here today because we received a letter on April 24th about this application. So we watched the recording of the March 20th hearing, and we were incredibly surprised by all this, but particularly by certain statements, allegations made by the applicant that at best were misleading and at worst completely untrue. So I'm here today to correct the false narrative that was presented to you and to exhibit that air dancers in general have many uses, including decoration. So, I think it's most important to note that prior to receiving the letter on April 24th, we've never been given any indication that anyone had a problem with the air dancer at all. We have great relationships with the vast majority of our immediate neighbors, and the only feedback we've gotten from anyone was positive, saying it's fun. And had anyone ever told us it bothered them, we definitely would have addressed their concerns. So for background, and regarding to my husband's point, the safety issue. I mean, to alleviate any and all concerns regarding my children's safety, they are never unsupervised outside. They are 2 and 4 years old. They're never unsupervised anywhere. Every inflatable we own has a similar safety warning that somebody was overly concerned about, to either not allow children near the blower to play with the decoration. It's pretty standard for almost everything that's not meant to be a toy to have that type of safety warning, not just decorations. So for background, we bought the Air Dancer as part of a series of Halloween decoration bag costume purchases toward the end of October 2021. The applicant argues that it's a commercial product, but I purchased it on Amazon where it was categorized as a holiday art decoration. And one of the reasons I purchased it, in addition to its high reviews, was because I've also seen it used decoratively at other residences in Milburn Township, and I thought it was a lot of fun. So we were originally planning to do like a Halloween village type thing for our daughter, where the playset was, because it was originally scheduled to be removed on October 25th. But the removal was pushed back a few times actually to November 1st. So we abandoned the Halloween village and we later put up a Hanukkah Christmas village thing. So our choice to decorate our yard had absolutely nothing to do with the applicant ever. It was rather to provide a distraction to our older child from losing something that she had considered hers. And I think it's really important to note that by the end of the summer, we actually no longer wanted the playset. I can elaborate later on why if anybody's interested, but it actually didn't work out for us and we really weren't sad to see it go. I mean, and we got a full refund for it. So everything was all good in terms of disposing of it. We were pretty happy to get rid of it. But I mean, all that said, anything we have ever done or will do on our property or in our yard has nothing to do with anyone except us and what's best for us and our family. So we first turned on the Air Dancer near the playset for a short time on Halloween Day 2021, not after the playset was removed as the applicant had said to the board, but what we then put it aside because the playset was going to be removed the following day. So it is a very, very low maintenance decoration that comes in 2 pieces. It doesn't require any stakes, and it is a whole lot of fun that I actually greatly enjoyed watching from my office in the attic where I spent Monday through Friday, 9 to 5, and usually longer actually. So we also bought a snowman for the holidays a few days later and left that up with a timer like throughout the holiday season. And unfortunately, a little longer. I mean, we just didn't pay attention. It was on a timer. I liked it. It wasn't a thing. But I mean, to be clear, that timer broke 6 months ago, so I don't really understand why we're here right now. Because we didn't put it on a daily basis at all since then, especially since the timer broke. I also find it sort of odd that this application is specific to Air Dancers because there are many other inflatables that we could use to decorate our yard. And this motion or whatever it is, this application wouldn't really prohibit anyone from decorating with those. Okay. Ultimately, everything the applicant had complained to the board about, which includes the Air Dancer obstructing her view of our yard and the noise, are all, I think, moot points for the following reasons. One, as I've mentioned, has rarely been on for at least 6 months. And actually, I think it would be a lot longer than that because as soon as the landscapers started coming and started turning it off, we didn't really turn it back on unless we were out in the yard with the kids and they wanted to see it. So, I mean, I think it was turned off or unplugged even when the timer was still working for a significant amount of time. So, and 2, over a year ago, the applicant planted a hedge along our fence with trees that are significantly taller than our 10-foot Air Dancer. So, let me see. And number 3 is the fence and the trees. And also in summer, the applicant's window air conditioning unit that faces our property, I would think, would certainly mitigate any noise produced by the Air Dancer's blower, which we don't think is that loud at all, and clearly not loud enough from the applicant's property line to have compelled the zoning officer or anyone else she may have complained to take any action on it. So, a couple things that I wasn't going to know, but I'll throw it in there because I'm already here. But the last time that my husband and I even spoke about the applicant to our neighbors was when they actually installed the hedge. I remember that conversation because that was when the setback rules changed for corner properties from the curb. So we could have put a playset in the exact same location as it was previously if we wanted to at that time, moving it 2 to 4 feet. You know, if we really wanted to bother them, I think that would have been the way to go. I mean, we weren't doing anything we were doing to bother them. So there's that. One thing that really irked me that the applicant said during the last meeting that was, that was categorically false was that we refused to compromise on the location of the playset back at that time. So I think that was the reason that she provided to the board for not contacting us about the air dancer. But my husband went over to their house twice, like within the next couple of weeks after the zoning officer came about it, to talk to them. And they didn't answer their door either time, even though there were 2 to 3 cars in the driveway each time. So he spoke to the applicant's husband, I think a month or 2 later, when he ran into him in the yard doing yard work. So the place that was 8 feet from our fence, and my husband Ed did at that time offer to move it to the required setback of 12 feet, which actually I think changed last summer to 9 feet. So, I mean, at this point it would have been just a foot away, but her husband's response to us was, no, that won't work, we'll still hear the kids. So my husband's response was that the kids will always play in our yard, so there's really nothing that can be done about that. And after that, we hadn't heard a thing about the playset. So them saying that we turned down an offer that they had to compromise is just outright false. I mean, we tried to compromise with them and were rebuffed. So there was that. Another point about the noise is if it were truly so consistent and bothersome to anyone, why would they just live with it for let's say almost 2 years at this point, rather than just complaining to the only people who could or would clearly do something about it. I mean, we've never done anything to say that we were unapproachable. We've never been rude in any way. We're just, living our lives. And I don't understand where all of this is coming from, to be 100% honest with you. So, I mean, I think that any reasonable, logical person that the applicant did complain to about the air dancer would at least offer the very basic advice to contact us, to write a letter if they don't want to talk to us, or, they have their lawyer write a letter to us about it before taking what to me seems like a drastic action of being here. So there's that. And based on all of this, watching the March 28th meeting did feel like an undeserved, unwarranted, targeted attack on my family for reasons I can't fathom. So the exhibits that we have, do I need to present them to anyone?
We need to label those.
What?
Do you have, so what do you have exactly there?
I just have, can I talk you through them? They're just Amazon purchases of when I purchased the air dancer. I circled the relevant
Do you have
portions.
copies for the board?
I'm sorry?
Do you have copies for the board?
I have this one copy.
Just your one copy? I have one copy.
I might have another copy in my
And you
phone.
can mark this.
So we can
We
pass it
just
around.
pass it around.
We just need to mark it
Okay.
together.
What do I need to mark it with?
Just 01 and today's date. We'll use,
have a paper copy, which
Okay.
is fine, rather than mine. I just made a copy.
You'll just pass it around.
Okay, I mean,
Board members.
I did it on the photo paper because it's just clearer.
So, that's right.
Whatever you want.
Yeah, we'll just do first,
Okay, what am I marking it with?
01
01?
and today's date,
01, 6/5/23. Okay.
and then you get that to Eileen. We'll just pass that around.
Okay, and I'll talk you through
Yeah, just tell
it.
us what you got in there.
All right, so page 1 shows my purchases starting on October 24th for Halloween and other miscellaneous items. I shop piecemeal. The top of the second page shows the purchase of the air dancer on October 20th. On October 19th, I made 2 other purchases of other Halloween decorations that we were gonna put on that side of the property to do like a Halloween village, but the ghosts were a little too scary to leave up for through Thanksgiving. So the air dancer was orange because the ghosts were sold out, but we figured it was seasonal, so that was fine. And then the third page on the bottom, you'll see Halloween costumes. I mean, this may not be relevant, but generally I do everything around this time of year very late because my job is, the busy season is summer. My final deadline is usually October 15th. So anything that I plan for, including Halloween costumes, unfortunately, is always quite late. But so page 5 shows the orange air dancer that I purchased on October 20th. The second page, you'll see circled it's number 23, categorized as inflatable outdoor holiday yard decorations. So on Amazon, you could go through items ranked from 1 to 100 of like the best-selling inflatable holiday yard decorations, which is how I think I found this along with the other inflatables that I bought, and I also did purchase another few inflatables from other sites. But on November 3rd, I purchased the snowman, and also ranked. I mean, he was ranked much higher during holiday season, but number 1,123 currently. But my point is that it's categorized that way on Amazon. It's an inflatable yard decoration. So pages 9, 10, 11, and 12, well, 9, 10, and 11 show reviews, including videos and pictures of it being used in residential properties. Some of the reviews are the ones that, helped me make the decision to buy it to begin with. Another thing about air dancers that I looked at is that they're actually also used as scarecrows for agricultural purposes. They're very effective. And we did notice, like, whenever we had it on last year, we had a lot fewer groundhog issues in the spring with our dog, a lot fewer dead groundhogs. So that was quite useful for a while. But on page 12, I took a representative sample of 1 month, March 11th to April 11th, because this was actually just a lot of data to go through. Otherwise, I would have done more. But I show what on the day and the times the air dancer was turned on and off. I have pictures showing that we were outside all of those times with the kids. And I think this is representative of the activity for at least this past 6+ months. And then I actually purchased the Ghost Air Dancer, I think right before last year, October 2022. And I accidentally bought another base, but I was planning to just use the one that we had, another blower. So now we have 2 air dancers. So we put the second one right next to our house, which was a bit of a mistake because there are way too many shrubs and trees, and it constantly got caught and was in our way on the path. But I mean, from a noise perspective, our bedroom and our den is right in the area, and our kitchen is right in the area that we had it. And it didn't bother us, and we left the window open throughout October. So on page 14, I sent an email a couple days after, on April 28th, which was 4 days after I received the letter, to our neighbor's attorney. That's the top portion of page 14. So I said, regarding your suggestion yesterday that the client may be open to dropping this matter from their dancer across our yard, my husband and I discussed this, and we proposed the following. So we said that the air dancer will be kept off except on holidays, as it has already been for at least the past 6 months. And for now, it was moved out of our yard entirely. My husband moved it that morning anyway, because our landscapers were going to do spring cleanup. So I also said, should we forget to turn it off after a few hours or so, if it isn't around a holiday, your client is welcome to text us to let us know and or ask that it be turned off, which we will promptly respond to. Out of courtesy, we will keep it no less than 10 feet away from our fence. From our fence. And I also asked the client to agree to inform us if they had any issues with anything that we do going forward before coming to the zoning board or any other board. So another thing that I wrote was, and I was pretty angry after we received the April 24th letter. Although we fully disagree with your client's intentions, which are seemingly to control what we do and how we decorate our yard based on your client's personal preferences and methods, which involve defaming us and not informing us of any issues prior to involving the township and lawyers, my husband and I feel your client's agenda is a gross misuse of Milford Township's public officials' time and our time, which is why we're making the proposal. Clearly, that wasn't good enough, so that's why we're here tonight. So additional pictures below that email, and then I don't think we've spoken to them since. You haven't, right? So no, we haven't actually been in contact with anybody about this since. So on April 24th, I wanted to take a picture of the view of where the air dancer is from my attic office. So that's why we put things in that inner area of our yard. That's where I spend most of my time. If I want to see my kids play, that's where they play. The second picture taken on May 21st, 2023 shows the hedge that the applicants planted in full tall bloom. All right, and then the next picture on the following page was taken on June 21st, 2022, which shows the applicant's air conditioning unit in their window. And then the next picture taken in 2019 also shows the applicant's air conditioning unit. And then on April 27, 2022, playing outside with the air dancer on.
Excuse me, I don't want to cut you off, I don't want to stop you.
It's repetitive.
It's not repetitive, the board tonight is to decide whether or not an air dancer is a permitted use or not a permitted use. This is not a case against you, you're not in trouble, we're not going through.
I'm not saying that I am.
I understand,
Yeah.
and, the
And
board has the pictures.
this was less for your benefit, I think, and more for the applicants and also to, well, I mean, it was also for your benefit because, I mean, there were a lot of misleading statements that she said to you, like we were only outside 5 times ever. I mean, there was a lot that was presented that was just
I
wrong.
understand, we're not talking necessarily about your air dancer.
All right.
We're talking about anybody that wants to put one in their yard, whether or not.
Well, I mean, I did have a list of questions that I wanted to present to the applicant, that I wanted to ask the applicant. I'm gonna ask, can I hold off on doing that? I don't want to waste any more time. I mean, if I decide to ask questions, can I do it later? Okay,
Yeah, so
all right,
I have one question for you, actually.
Sure.
So no point has your neighbor reached out to you?
never about anything. Like so recently, one of our neighbors actually told us that, I mean, in light of all this, we talked about this with our neighbors, but one of them said that, I think last year, they saw a New Jersey Department of Health vehicle parked in front of our house inspecting the air dancer. And, they didn't think anything of it at the time, but now that this is happening, they decided to mention it to us. So, I mean, I'm curious how many people she did complain to outside of us. So, no, we didn't hear a thing, but at the end of the day, so, all right. I guess in closing, I feel that this application should be denied for many reasons, including air dancers are used for decorative, not just commercial purposes, and clearly use it for the former, not the latter. This application is oddly specific to a certain type of decoration, so we are clearly targeted in that for reasons, again, that I can't fathom. Applicant misled and/or lied to the board with many of her statements. One of them being also that I remember when watching the video, her lawyer asked, on a typical day, such as today, when is the air dancer on? He said, wait, on a typical day removed, such as today, because that day it wasn't on the day before or the day before, and many days before that as well. So anyway, and also we will make sure going forward that the air dancer is at least 10 feet away from our fence when it's on. All right, that's about it. Thank you.
Yeah, thank you. Counselor?
Have some questions.
Sure.
Do we have to stand up here?
I think you need to be on the mic.
Yeah, it's just
Okay.
easier on the mic, so.
How are you, Mike?
Great.
Just a couple questions. You testified, at the beginning of your testimony, you said you had seen these at other homes in Littleton. Can you give us their address? Can you give us the address?
Honestly, there is one on the corner of Myrtle and Maple Terrace that had it, what? Yeah, so we can give you that address. So they had a
They put it up every-
snow
What
management.
is it?
Yeah, and they put it up every year. So we definitely saw that last time. As we drive on Old Short Hills Road, Parches and Nicholas Road, we see various decorations, including air dancers. And had we known we would have been here tonight, we would have taken pictures and noted those addresses.
But you don't know the address.
32 Maple Terrace, I think.
32 Maple.
Is that on? No.
Yeah, it's okay. No, it's on the side. I'm sure we see others, but I walked my dog past
We
that.
did them one at a time.
Yeah.
I noticed on your exhibit that was marked 01. Well, I'm gonna go back to the first question. So you've seen it at 32 Maple Terrace, I think. Any others?
No, we've definitely seen it there.
No, I understand that. Any other addresses in Milton?
We haven't had, it's not holiday season. If we knew we were gonna be here, we would have taken the pictures and noted it.
So you've only seen it during holiday season?
Yeah, actually.
Yeah, I think
Yeah.
So one person?
Yeah, if you just do that, it'd be helpful for the record.
I'm just trying to help you.
You could just.
So only during holiday season, is it in the front yard that you see it or in the back? No, sir, your wife testified, I'm asking for questions. You didn't, these are questions directed at her testimony. It's not fair to the court reporter to have two people talking at once. And respectfully, I'm trying to do cross-examination based on what the testimony was, not based on someone else's opinion of what they think they saw.
We get it. You're speaking to that.
Okay, air dance, well, I mean, specifically not an air dancer. There, I think I saw it in the front yard, but we don't have a good view into people's backyards normally.
I understand.
But also, I mean, I have seen decorations on corner properties in their backyards that may not specifically have been the air dancer.
We're only talking about motorized air dancer, blower type equipment, not,
I've seen inflatables in people's backyards.
so we're only talking about the things that you plug in, that have a fan, that glow and make
Okay.
noise. Not a Santa Claus or Rudolph the Red-Nosed Reindeer or an inflatable jack-o'-lantern or some kind of ghost. Just talking about that. So the house at 32 Maple had a blower operated device
It was a snowman, yes.
and it was moving around like
Yes.
this. Okay. So I noticed in your Amazon order sheet, it looks a lot. You had other Halloween items.
Mhm.
Were those items put in the backyard or did they go in the front?
They were intended to go in the backyard,
But
but
did
they
you-
were Halloween specific. The air dancer was orange.
Did you put the Halloween items in the front yard by your front door?
Did we put them there
Ma'am,
at any point that year?
Ma'am.
Well, I don't think we put them out at all.
So if you don't know, then just say I don't know.
I don't know.
You said you never talked to anybody about this. Is that, do you remember saying that?
And, well, definitely not the applicant who's the most relevant.
Did you talk to the chairman? Because he said at the last meeting, he came to your house and saw it. He said he talked to you.
About the air dancer?
No, I spoke to you about the previous,
Yeah, the playset, yeah.
not the
Okay.
answer.
Nobody talked to me
Okay,
about.
I apologize, and I thought you had said you went there in December.
No, I passed the house down multiple times.
Okay, no, when we saw the video, it seemed like you said, I saw it, it's a Christmas decoration.
No, let me clarify. The conversation that we had was when you had the original application for the
Playset,
swing set,
yes.
correct?
Okay. Now, you said towards, I think the end, that the list in '01 was a representative sample of how frequently it's been on for the last 6 months.
Yes.
What about before that?
What about before that? It was on more. It was on a timer.
Okay, so, and then the timer broke.
The timer did break, but I think it was on, like I said, when I spoke, I believe that even before the timer broke, it wasn't on every day because it was constantly unplugged or turned off
What
by the
was-
landscapers or whoever.
Was it a mechanical timer or a digital timer?
It was a digital timer with a battery backup.
So when it was on before, that wasn't necessarily a representative sample. So like I saw that you turned it on for, hold on, I saw that you turned it on for 2 minutes one day in April. That wasn't what you were doing other times.
I mean, when it was on the timer, no, and I testified to that, but
How long was it, when the timer was working, how long did you keep it on for?
I think it was about from 8 a.m. to 7:30 p.m.
And were people outside?
I mean, not usually, no,
Okay, so you just turned it
but people turn on holiday decorations when they're not necessarily outside.
on. Okay,
Which is
when, did you have it up in, for instance, April of '22?
Probably, but I did also put it out because that's when birthdays happen. I put it out for other celebrations.
So that wasn't a holiday decoration.
Well, it was a celebration decoration. It was a birthday
Okay,
decoration.
what about May, for instance? Birthday too?
May, no,
June,
June, I don't, yes,
July?
July, yes.
Was the air dancer out that whole time?
The air dancer has been out for the past few years. We never brought it inside.
I understand. So it was on from the days that it was on all day.
Well, no. The days that it wasn't on all day for the past like 6+ months.
No, I'm talking about before the application was filed. Not before the timer broke.
Oh, I don't know when the application was filed. I didn't get any of that
I
information.
understand. So, but when the timer was working, so let's say in 2022, it was on all day, every day?
Right, but they also had a hedge. And there was also air conditioning units in the summer.
What they had.
And they also didn't tell us that it was a
The question
problem.
is, did you have it on all day? And if the answer is yes, that's okay. What's on someone else's property isn't the issue here. We're asking, is this customary and incidental to a residential use in
Okay.
the R3 zone? Someone's air conditioner, someone's cats, not relevant. But why did you include the picture of the cats?
I mean, it was more because I knew they were gonna be here today and I knew they were gonna see it and I think they needed to see it.
What does it have to do with, what does it have to do with the narrative?
I think that it was just her testimony was that people were scared to speak to us and that we were doing it out of spite and disrespectful of the neighbors and they're disrespectful of the neighbors in many ways.
You didn't,
And I didn't speak to it. You're the one who's bringing it up,
it's in your packet, you submitted it to the board.
which I don't know if they looked at until
we
now.
stay on the air
Nobody spoke
dancer?
about it.
Absolutely, no, I just wanted to understand why she included that picture in the packet. That's all I have, Chairman.
Okay.
Thank
you. Any other questions for neighbor here, for the audience?
Can I ask one question?
Go ahead.
So in the exhibit that you provided to the board, in the pages that reference the inflatable tube man in the Amazon website, I see that it does, it looks like the pages that it's on are are described as inflatable yard decorations. But when you look at the description of the product, for both the snowman and the tube man, it says it's designed to grab attention. The dynamic waving motion, fringed hair, eyes, and iconic face attract customers to your business and bring attention to whatever you're promoting. Did you understand, was it your understanding that the product was for yard decoration or that it was for a business purpose?
No, it was, well, I mean, I looked at the reviews and all the reviews of the people who used it was for yard decoration. So I don't buy things without reviewing the reviews. I mean, if this was specifically for a business, then, and all the reviews were like, yeah, I got a lot of people there to my business, then, I mean, I probably would have passed on it, but it was included as a holiday yard decoration. And to be honest, as long as, the product descriptions aren't incredibly misspelled, mispunctuated, and aren't terrible, I don't really pay that much attention to them. But I mean, I look at the reviews and I see how easy it is to use a product where it's made, and then I'll buy it. And like I said, I've seen this other times in the neighborhood. I think I've only really seen it for commercial purposes. Actually, I don't even know if I've ever seen it for commercial. I mean, I can't recall if I have, because I grew up in New York. And I mean, I know this is used for commercial purposes, like the 20-foot ones. And based on what I've seen on TV, it's used in very rural areas to denote that there is a business in a particular location for passerbys. This was just for fun. This was a decoration for fun. That's all it was.
I have a question. So you keep saying that you've seen it around the town, but then you also said that you're not looking really into people's backyards. So when you see it, are you mostly seeing it presumably in front yards?
I am mostly seeing it in front yards, but I live on a corner property with a very low fence. So anybody from the street can see directly into that. So that's part of a front yard. And my front yard is actually, the topography is very hilly, slanted. So putting any inflatables out there, even the ones that stand still, have been fraught. It's been very hard. So, I mean, they topple over a lot because, I mean, there's a lot of erosion. There's a lot of erosion, which we need to do something about. But basically, there's a lot of, because our property, both facing Wyoming Avenue and Chestnut Street is very close to the street. It's very hilly. It's hard to put decorations there. And we have a very low fence. You can see that area from the street, and there are no trees that block it. It's just easy to decorate, and it's fun. We can run around there. I mean, it's a huge space to run around in that you can see. And it's just, that's what we prefer to do. I mean, it's a personal preference more than anything. And like my husband said already, I mean, I have to be honest, we could live without the air dancer. I mean, if it is outlawed or whatever by this town, we're fine with it. It's not a big thing, but life will go on. But it is fun. Other people use it. I don't think, it's sort of a fair thing to target this specific, this specific item or inflatable. But anyway, I think unless anybody has any other questions.
Board have any questions? Thank you.
Okay. All right, thank you.
Councilor, anything else?
Well, does she want to ask questions of Ms. Miller?
No,
I just have two small bits of follow-up with Ms. Miller, if the board will indulge me.
Sure. I also have a question as well for Ms. Miller.
Okay, I'm gonna put this in front of me. I'm gonna hand it out. I think we're up to 8.2.
We're up to. Correct, only they want, me too.
Just pass them down or whatever.
Michelle, you're
Yes,
still under oath
okay.
because of my last time. What is this document?
This is a log of the times that I personally witnessed the air dancer on. And I started the log when I first saw it on November 3rd of 2021. And I stopped it in January of this year.
When we filed the
When we filed the application.
Okay, and so there may have been times when you didn't see it, that it was also.
Yes, because I often would anticipate it would be on, and I left my house, and I, a lot of times wouldn't come home until after dark because I didn't want to be exposed to it.
All right, I'm gonna pass out A3. So we collected a little bit of additional information, is that correct, Ms. Murray?
Yes,
Where'd you get this from?
got that from the manufacturer's website,
Okay, so
or the
that's,
vendor, lookourway.com.
okay, I'm gonna ask you to turn to, some of these were already in A1. But I want you to turn to the second to last page. So we saw in '01 that this was a 12-inch blower. Can you tell the board what the manufacturer's specs indicate about a 12-inch blower at 20 feet? Well, in terms of volume?
12-inch blower, 67 decibel.
Now, you and I spoke before the meeting that the decibel scale is a logarithmic scale where each increase of 10 decibels is 10 times the volume, correct?
Yes,
Now, if something is 10 feet from your property line, which is closer than 20, it's louder than 67 decibels. Is that correct?
yes,
And I'm gonna tell you, and I don't know if you agree with me or not, but distance reduces sound effects by 6 decibels. So if you go from 20 to 10, it goes up by 6. Do you understand that to be true?
I
And you're
I
basing this on
honestly,
what?
I
You're
don't
an
know
expert
the
in
answer to
sound?
that, yeah.
No, it's math. It's math. I mean, it's high school physics. But I'm asking her if she understands it. If she doesn't, then that's okay.
No, no, I
Okay,
don't.
she doesn't understand it.
Okay, then that's fine. But you're closer than, this air dancer has been put less than 20 feet from your property.
Yes,
Based on what you can see.
based on the photographs and my observations.
Do the trees that you planted on your side lot line block the sound from the air dancer?
No,
That's all I have. Thank you.
Do you have a generator at your home?
me?
Yeah.
No,
Have you ever approached your neighbor about this issue?
let me just,
That's kind of a yes or no answer, but
If you answer the question.
no, no.
have you approached the township about it?
I called the code enforcement officer
Have
in
you talked to
November.
Alex McDonald about it from the township?
Yes,
So why didn't you approach your neighbor, but you approached the township?
because it's obvious that she was doing this to me intentionally to hurt me, and I didn't want to have any kind of contact with them. And I also felt that from a perspective of using it in the town, that it was not the right thing to have, nor did I think it should be allowed. That's why I came for the townwide interpretation to whether it would be applied townwide.
Does the township have an ordinance relating to the noise from inflatables?
To my knowledge, the township has a noise code, and they also have an ordinance under, I believe, the Board of Health.
Right,
For
in
noise.
relation to inflatables. I mean, because obviously you have
It's not,
generators, right?
it's not a general inflatable in my mind. Per the website, it's, it uses a commercial grade unmuffled blower. So it would be
That's
an
okay,
air
so-
dancer.
Okay.
I don't know a specific, it just uses a commercial grade unmuffled blower.
Okay, thank you. Any questions from the board? Any questions from the audience? Good.
I don't have any questions.
Any comments then from the audience regarding this or any testimony we've heard this evening? Counselor, anything else?
So Chairman, I subbed up at the last meeting. I don't really have anything else to add. I mean, our position was and is, this is not customary and incidental. We talked at the end of the last meeting about imposing conditions, which obviously the board can do on a permissible accessory use, but the predicate finding is that it has to be customary and incidental, and I don't think that the evidence reflects that it is.
Thank you. In that case, I will close the public portion.
I don't know.
So, board members, what say you?
I have some thoughts about this. I think that there's obviously a lot of emotion in this, and I think that we really need to take the emotion out of it. And I'm reading, what the applicant is asking. It's saying they're seeking a determination if the structure shown in the photograph constitutes a permissible accessory structure in the township's R3 zone when located in a side or rear yard. Just want to make sure that I'm understanding that correctly. Is that what that's what we are voting on right now?
We're voting on whether this is an accessory use or permitted accessory use or not. We're deciding whether or not a blower dancing band is customary and incidental to a single-family home in
The side or
the
rear
R3
yard?
zone.
In the side or rear yard, or just in the entire R3
It
zone?
doesn't have to be a yes or no answer.
Okay.
And when Mr. Stanhagen talked about conditions, we're not placing conditions on the neighbors.
Mhm.
We're saying
Because it's general.
it's general.
Townwide.
If you want to place a condition, you can say it's not incidental at 3 o'clock in the afternoon. It's not customary. It's not customary at 3 in the morning. You can add something to that. So if someone's going to make a motion, you can say it is customary and incidental at this time, that time, for this purpose, that purpose.
So my feeling is that it's customary and incidental. I don't think it's customary and incidental in a side yard or a rear yard. I think that that's an invasion of, I don't know, people's ability to enjoy their side yards and their rear yards. I think that I haven't seen the tube man necessarily on residential properties. I've definitely seen inflatables. They're all in the front yard. And I think that that's okay. And it's generally for holidays. And I think that that's okay. Don't have an issue with that. I'm not trying to legislate or control what people do. But I think when you're putting something like that in a side or a rear yard, if you want it there so badly, then you should come before our board to get, a variance for it. I just don't think these things have a place in side yards or rear yards. The opposition said, that they have all these issues with their front yard and why they can't put things there. If that's the case, then just like any other matter that, we would have before us, then I think you come before the board. I don't see a place for these in side yards and rear yards. Generators are, Craig brought up generators. Our next door neighbor has a generator that sounds like, an airplane taking off. And when that thing, and it backs up into our, it's their, side yard in our backyard. When that thing is on, it is deafening. We cannot sit outside in our backyard and enjoy it during a power outage because it is so loud. So the thought of an inflatable being, in someone's backyard right up against mine, I just don't think there's a place for it. So that's my feeling.
And you're referring to the air dancer.
Any kind of air dancer. I don't think that they belong in side yards or rear yards, front yards. I think I'm fine with that.
Thank you. Any other comment? Go ahead.
Thanks. So our task here tonight is to determine if this particular usage, this particular object is a permitted accessory use, and that is defined by customary, incidental. Is there a third adjective?
Subordinate.
Subordinate.
It's not in your ordinance.
Subordinate is not in the
No.
ordinance.
No.
Okay,
It just
so
says customary incident.
so customary incidental. So I'm a person who decorates for many holidays, and that is why I'm struggling with this because and it's not unusual in our township to have decorations, outdoor decorations for holidays. The thing that is striking about this case and makes it so difficult, of course, is the emotional and the conflict between the neighbors, which is difficult for us to witness as residents, but not what we're here to mediate tonight. So I agree with Jessica that one of the things that perhaps makes this less customary and incidental is the fact that it is in the backyard and an invasion of perhaps the privacy of the neighbors. One of the speakers tonight said that what we do in our yard is our business and really doesn't affect others, but that is actually why the zoning board exists, so that we are good neighbors to everyone and so that the things that we do in our yards do make us good neighbors and make sure that the things that we impose upon our neighbors are acceptable and not infringing upon their rights for peace and privacy. So in my mind, the duration of usage of this decoration exceeds that which is customary in our township for other holiday decorations that I've seen, that I've witnessed. And I agree with the side in your yard a component of this non-customary denotation.
So I struggle with this. I understand my colleagues' point of view here, but one of the things that sort of is glaring to me is that this is not a systemic issue in town. So what we're doing is when we make a decision here, it covers the township. This seems more to be an issue between neighbors. And to me, the glaring issue here is that the neighbors have not communicated. And I think that a lot of this could be avoided if there was communication. The applicant has communicated with the township, the township administration, but for some reason, talking to their neighbor, which I think would be the first line of action, has never occurred. So for this board now to go out and blanket say, okay, this type of inflatable or whatever it is now no longer allowed in the backyard, this particular one, I think is kind of extreme. That we have one issue here, which to me is a civil matter. I'm not even remotely convinced that this is some sort of accessory structure. I think it's a temporary type issue that you inflate it, you don't inflate it, whatever. And I'm not really sure that this board is the arbiter of what's good to inflate and what's not. And where does it stop? If someone puts a 12-foot snowman in their backyard, is that unacceptable? Or this comes down and something else goes up, are they back in front of us saying now those should be outlawed? Where does this end? Is it just we do air dancers and we're good to go? Or do we just start outlawing everything that comes in our way because the blower may be too noisy or this may be too noisy or that? I think this is something that should stay between the neighbors, and I'm not sure that this board, the way it's described, I don't think we have heard yet.
I don't know. I think that's, and I really do respect that view. I mean, it is a legal question as to whether the applicant has the right to ask for this ruling. And, no one can disagree with anything you said up front, that, the relationship between the neighbors clearly has deteriorated to a point where things were not done in a way one might expect them to be done. But that's not really what we're here to decide. And so I think the legal question is, does the applicant have the right to ask for our opinion? And we can go either way, but I don't know if we have the right to not decide it.
Applicant definitely has a right to come in here and ask a question for an interpretation. If the board feels this is not a zoning issue, not something for this board to decide, that motion can be made and that vote can be taken.
So I just want to build, this is categorized on Amazon as an inflatable yard decoration. We don't vote on decorations, so.
We're voting
They're
on
asking-
the ordinance, not Amazon.
Understood, but so I'll just, from what Craig is saying, I believe it's also an inflatable decoration. So the question is, but the question they're asking is this, even if we say it's an accessory structure, it's not an accessory structure. If I say, I don't think it is, but it's a decoration, we don't rule on how long you can leave a decoration in your yard, right?
But I think there is a
that
question
there's-
about whether it's a
yeah.
decoration
decoration
or
I
not
didn't think we were
permanent
saying like a
accessory.
decoration. I don't think we were being that broad. I thought that we were talking specifically about air dancers.
Exactly.
You wanna put up a big huge snowman or a, something else. We're talking about air dancers with these really loud blowers. And I'm sorry, I can't help but feel that, we have it right before us where we're in a position to say yes or no to having these things in side yards and rear yards. This is not a personal thing for this particular property, but we say, sure, go ahead and do it. What if your next door neighbor does it? What if your next door neighbor, what if everyone in here, starts putting these things in the backyard? I just don't think backyards and side yards are the place for them. Not saying anything about general Amazon decorations. We were talking about a specific thing, air blowers, not even just a tube man, any kind of air dancer that have these loud, decibel blowers.
I have a question for council. Can you define customary for the board?
It's really anything that you would see in a neighborhood, anything that sorry to use the word customarily, but anything that you would naturally see or expect to see on an everyday basis in a certain neighborhood.
On an everyday basis, and is it seeing one? Does one meet the
Well, it could be
criteria for customary or
customarily
more
on
than one?
Sorry. It could be customary, you only see it on holidays. You could say customarily an orange dancing man, tube dancer is only on Halloween. It is this board's duty to interpret the ordinance and say what is customary in a single-family neighborhood in the township of Millburn.
Is customary defined in the ordinance?
No, it's pretty much just a general term. It's customary. It's something that you would
Common
expect to
sense.
see at a certain time,
Because-
date, every day. every
Because
other day.
the one of the speakers tonight, one of the people under oath said that there was one other that they knew of in the neighborhood. Does that make it customary, or is that up
In
to
the
our
front
opinion?
yard.
In the front yard, right, they've seen one. Does that make it customary one? Or is that for us
That's the way
to
you
determine?
interpret
Okay,
the ordinance
that's
in
for
terms
us to interpret,
customary,
so,
correct.
okay. Thank you.
I've yet to see it inflated in the house, past the house now 4 or 5 times, and I haven't seen it inflated. So I don't even know what this thing
Yeah,
is.
she said the thing broke 6 months ago.
Right, so I keep going
Right.
past it and I don't see it, so I'm waiting to see. what
She
it
could
is.
get a new timer.
I guess we need a motion of some kind.
Anyone else have any comments?
I'm also torn, and I do agree with the comments that Amy had said that, this does seem like a decoration, so why are we even talking about this? But from a pure legal perspective, I don't think that it is customary to see it as a permanent structure, whether it's in the front, the side, or the rear, something that's there every single day of the year. So if we're looking at this very strictly, I think we're,
So is that the case then, when would you allow it? Never?
No, not never. To me, it's more of a duration issue.
So if you-
Around holidays, around,
Right, but so like
birthdays.
if you went Christmas, you had the Santa Claus.
Mhm.
Or a Hanukkah decoration during December.
Mhm.
Then you transition to, in March, to something seasonal. Then in April, it was called Easter. Then on July 4th, you put up the American flag one. So when is it not okay to have a seasonal decoration?
And I think that's a hard
That's where it
question,
gets tough,
which
right?
is why
Yeah.
if I was to propose, a motion right now, my motion would be no, air dancers inside or rear yards. That's just that, because I think it's very hard exactly what you're saying, Greg, to come up with like the duration and when is it okay, when is it not okay? It's okay, just as long as it's not in your side yard or your rear yard.
but the other issue is we were saying.
And we're not saying anything about any other decorations, purely air dancing decorations because of the, loud noise associated with them.
So you're having a birthday party for your kid and in the backyard and you want to put 3 or 4 of these things because they think it's neat, the kids like it.
Mhm.
Can't do that anymore.
Yeah.
Is that?
Well, maybe not all year.
So Jessica, how does that address
Well, then
your
how do you limit
sound
that? So
issue?
that's a good.
What?
I think, I'm not sure we can legislate duration. I think it's just gonna be too difficult to do.
Well,
So you just
if
have
it's
to
a holiday
also- I think
decoration, then there is
I think you
implied.
could say we're not allowing them at all because they're not really appropriate for residential areas. Or we could put a limitation on it, like you can't have it in the backyard or the side yard.
And I'd say to your question, put up something else. There's so many other fun decorations that you could do if your kid's having a birthday party. Doesn't need to be this. And
Jessica,
that's-
you
you know.
made a good point earlier, Jessica, about the sound, right?
It's a sound issue.
And
It's not this silly thing in front of us. It's not about that, you know?
it's certainly an
It's a
important,
sound issue.
it is a very important issue, but with, saying not in the back, not in the side, but okay in the front, how does that get solved? The sound issue?
Because I think I think it's too hard to ban it everywhere. I don't think that that's really our place, and I think that it's customary. I think this gets back to the legal question that it's customary to see it in a front yard. I drive by during the holidays and I see it in multiple front yards. I don't think it's customary and reasonable to see it in a backyard. But I could make the argument that it is absolutely customary and reasonable to see it in a front yard.
So this yard, just to play a little devil's advocate, so this yard is visible from the street.
Mhm.
If your yard's not visible from the street and you put one up.
Yeah.
Is that a problem?
If your yard's not visible from the street, you mean your backyard or your side yard?
Right, so right now it's backyard or side yard. So your side yard or backyard is not visible from the
Yeah.
street and you have one in there.
Yeah,
You'd be technically violating our new law.
yes.
I want to ask a question. We're being asked to say, is this an accessory structure?
Correct.
Or permitted use.
A permitted accessory
Permitted
structure
accessory
slash use,
Right.
yes.
structure.
Which I don't think that bars the cross. I don't think it's
Which
accessory.
has, so let's, I just want to hypothetically, if we say it's not, okay, it doesn't mean you still can't put up a decoration in your yard, it's not our purview, right? Any kind of inflatable, whatever, we say it's not an accessory structure, okay. But that doesn't mean I can't put up my Christmas decoration and there's no ruling that I'm aware of in the town, there should, like, how long can I leave my Christmas decoration?
All year long if you want.
Right, so, yeah.
We can't give our opinion as to what hours we think are best,
No, right, I'm
what
just,
we
I think we
want.
have to get to
what's
like, what is an
customary.
accessory
I think it's
structure,
really,
yes or
I
no,
would move
and, like,
away from structure and go to use.
But it doesn't
And I-
mean
and
somebody
I
still can't put it
Right,
up.
agreed. And I would say this use of a what do we call it?
Air dancer.
Air dancer, is not appropriate. We're not saying anything about inflatables, not saying anything about holiday decorations, not saying anything about anything else. We would just be saying that an air dancer in the backyard or the side yard would not be permissible.
I would
But not a
rather
permitted
just
use.
say an air dancer is an accessory structure, not an accessory structure, and then go do what you want, because it,
Yeah, I'm not sure,
That's
I'm
kind
not
of
sure, I wouldn't be comfortable in telling people what they can and cannot put in their yards. Because I don't know where it stops.
Yeah.
If how many people have issues with their neighbors and they come in front of us to say, no, that fountain, that, this or that, or
But I
thing that
don't
they
think
like.
we can't, you always say you can't, make up
Well,
things that are
this is not a
not, you know what I
systemic issue in
mean?
town.
I mean,
We
what if I put up my
It's,
inflatable air-filled kitty jumper thing and I leave
But
it
that's
up?
not an air dancer that has like that loud decibel.
I hear you, but you
blower.
had gone beyond, I think, to say blowers things, just.
No, I
just
said
air
an air
dancer.
dancer because they have blowers that are a very loud
And
decibel.
when we say we
So
would
it's
never,
not
there's
unusual.
we only have the question of an air dancer in front of us, but are
Yeah.
we saying that there's never any structure, decoration, or anything that could ever exist on a property in Milburn that we would say that's just not appropriate for the town?
I think that'd be up to township to determine, the town council.
Craig, just a question for you, because you've talked about how far can we go with this. This board has put conditions on things like fences and generators, to put plantings in front of it just to make the view better for the neighbors. So it is a consideration here, like how do we make this better? How do we make things such as this better for the neighbors? And this not only has a noise component, but it also has a pretty
His neighbor.
neighbor has a visual component as well. It's waving and it's waving 10 feet up and possibly more on top of the bluff. So there's multiple things that could be irritating. However, the question in front of us is this customary and incidental to this particular single residence in this zone?
Not this particular residence, single-family homes in this zone in Millburn.
Okay,
Not
And
this-
when I say
Right.
conditions, The neighbors that have the air dancer are not the applicants here. We're not saying you can put it up only if you put up trees in between. We're saying as a town, are air dancers in this type of situation customary to
Okay,
accessory uses? And if we were to say, well, you can, but only if you put up a screen, now we're starting to legislate.
Okay.
Because we don't really have a solid record of how many there are in town and how
Right.
many have trees, how many don't.
okay.
So,
I'm just using it as an example of
Correct.
I
sometimes
did think
we,
at the last meeting, Rob had said we could put, I'm not advocating this because I think the conditions will make it too difficult, but we could put whatever conditions we want. It would apply broadly to the town, not to just these
I would
people.
be uncomfortable with that.
I
going that
totally
path.
agree. I
Yeah,
totally
it's just
agree,
a-
but I just to be clear,
Sure.
I thought that was the advice.
I'm wondering if, are you able to remind us the definition of a permitted accessory structure?
the list of permitted accessory structures,
Just how it's defined, I guess. Because that's what we're ruling on. Is this within the definition of a permitted accessory structure?
well, we're really going towards the use itself. Is this air dancer a permitted accessory use? In this neighborhood, in Milburn, is it customary to see something of this nature?
can you define incidental?
It's not a dual primary use. It is, you have your primary use
I'm
and
trying.
you have something incidental. Like a doghouse is incidental to your home. It's something, it's customary and incidental. It's part of your home, not connected to your home, but it's associated with a single family home.
I have one other, when you talk about permitted accessory use, does that, so accessory use means permanent or not?
Does not necessarily have to be permanent.
So do I have a motion?
I'd like to make a motion that air dancers are not customary, reasonable, or permitted, and therefore not permitted to be located in side yards or rear yards. Is that, I just want to make sure I'm phrasing that the right way.
If that's the
Okay.
motion you want to make,
Yes.
that's fine.
Okay, just making sure that that's.
Is there a second?
I'll second.
Could we modify that to say they're not permitted accessory uses inside or rear yards? Because I think there's a difference.
It's more specific as opposed to merely possessing one in your side or your rear
Because
yard.
I think you could put one up for a day. But it doesn't make it a permitted
What we're saying,
accessory use.
sorry.
Yeah.
What we're saying is, as for this motion is, they're not going to be allowed inside and rear yards.
I understand what the motion is, and I'm saying I'm not sure I agree with that.
Well, that's
I don't
okay.
know.
I mean,
Yeah.
so we have a second.
Yeah.
What's the wording?
Wording?
The motion was, air dancers are not customary uses in a single-family home in Milburn, therefore they're not permitted in your side or rear yard. They're not customary in a side.
In
or
a
rear
side yard, so therefore not permitted, yeah.
Should we have the word
Inside or
incidental to
rear
make
yard.
it completely
If you
consistent
wanna
with?
add the word incidental, we can
Because we
add
know it's not incidental,
customary
but I
or
mean-
incidental.
I- we don't have that.
It's not, it wasn't in the, it's not
I
in
think
the
it is
ordinance,
incidental.
so, yeah.
I think it is.
Yeah, it's incidental. If it was not incidental, it would be an actual use of the property, like a significant use of the property.
But we did make the argument that it could be
I don't think
a
legally it's
business.
incidental.
Okay.
All right,
Further
there's a
our
motion on the
counsel, it's
table.
not
Let's,
incidental.
we need to vote.
It is incidental.
Could you
I know, I
repeat,
know.
Could you- I think we need a repetition of them.
Yes.
yeah, could you repeat it one more time, the wordings?
Ashley Abdul,
Yes.
Chandra Harjani,
Yes.
Amy Lawrence? No. Gary Rosen,
Yes.
Eugenia Trillia?
Yes.
Jessica Fly?
Yes,
Rick Butler?
No. Next case.
Chairman, members of the board, thank you. Good evening.
Sure.
Yes.
Calendar 38 7822, Paul Di Leo, 19 Bodwell Terrace in Milburn.
Very good.
Good evening again.
How you doing?
Sure. Good.
You do swear.
He was previously sworn, and tonight you have with you who?
I have guests.
Okay, you have guests. All right, good. So,
I have professionals.
when they come forward, we will need to qualify them.
Okay.
Okay, so you may start and then introduce who.
Jessica and Sean Drew, we're not here on April 7th.
I watched the,
You watched it, Sean Drew, did you watch it?
I have not.
Okay.
I'll be back.
So,
Continue.
based on our prior conversation, we thought it would be helpful to have our planner and architect, as well as do some renderings that show, what we're talking about in 3D so that everybody can understand it. We have handouts as well. They're all labeled and dated. And with that, I'm going to introduce John McDonough.
So what you're talking about now has not been entered, correct? Or has been?
Has not been.
All right, so we need to-
A2.
Label it A2?
Correct.
Okay. So that's gonna have to be labeled then,
Well, we can label this package as A2 photographs, 4 photographs A through D. They're already dated 6/5/23. No, this is A2, which is a compilation of 4 photographs, A through D. And what's in front of us
Is
labeled
the,
D.
the after shot of the.
wait, so you're referring now to B. In, here we go. Okay.
So with that, I'm going to hand it over to John McDonough, the planner.
How are you, Mr. McDonough?
Hi, Mr. Chairman.
Swear in.
Do you swear affirm testimony about to give tonight's proceeding be the truth, whole truth, and but the truth?
Yes, I do.
Name, please.
For the record, John McDonough, MC, capital DONOUGH, and I'm the project planner. That license is current and in good standing, both on the national level and on the state, on the state level and the national level as well, AICP. I've been here many times, Mr. Chairman.
Thank you very much.
And I'll just say, I promise not to use the phrase customary incidental once during my, which for the record in planner speak means commonly subordinate. That's the easy way to remember it.
Please continue.
Okay, so we think what the applicant is doing here makes good common sense from a planning standpoint, putting a physical addition over an existing dwelling over on Bodwell Terrace. We're going to give you some visuals to show that this is a good marriage with the site from a physical planning standpoint. We're going to give you some analytics as well to show that this marries up well with your ordinance and your controls. Your 2018 master plan has some good language about why you have floor area ratio controls. That's the primary relief that the applicant is seeking here. Concerns, particularly in the R6 zone where this applicant is located, in protecting neighborhood character, avoiding development that is out of sync with the neighborhood, and ensuring that new development is not excessively bulky. You have numerous references in your 2018 master plan about concerns about tear downs and what it was doing to the neighborhoods, especially these smaller R6 zone districts. With that said, I think we're going to give the board some orientation. You saw the visuals that were just handed out in terms of the before and the after, what the applicant is looking to do. A relatively modest addition on the second floor. We've got, I'll say, a built-out first floor and then a partial second floor. I'll give you the numbers in a second. But what the applicant is looking to do is essentially square off that second floor to provide an additional bedroom. So this would become a 4-bedroom house, which is what we see most of the homes on the street have now, 4 bedrooms or more. So sort of bringing this house up to scale with the rest of the neighborhood from a bedroom count standpoint. With that, Mr. Chairman, we're going to give you just some visuals here, some aerials and some maps of the property, just to give everybody some orientation.
These are not marked.
Thank you.
It's gonna be A3, it's 5.
And A3, for the record, will be 5 pages. It's all stapled together, so Counselor, I'll just go A3 sheet 1, A3 sheet 2.
That sounds fine.
So we'll start with sheet number 1, which just gives you orientation here. We're talking about an interior lot on Bodwell Terrace. There's about 22 dwellings or 22 lots that Bodwell serves. And this is a fairly typical lot in the context of the neighborhood. Again, it's mid-block, and we're going to give you some of the analytics on these lots as we go forward. It is a piece of property that is developed with a dwelling that was constructed in approximately 1932. Most of the homes here on the street were, I'll say, Depression-era homes that were built in the 1930s. So from a physical planning standpoint, in terms of the overall mass and scale of the buildings and the size of the lots, we do see some good harmony here. And importantly, the applicant is putting this addition at the back of the house. This is going to increase the second level on the back of the house. And then in addition on the top with the dormer for some additional attic space. The property itself is approximately 6,218 square feet. And the dwelling consists of a first floor that is presently 1,118 square feet. And then that partial second floor is smaller, it's 832 square feet. As I said, Bodwell Street is developed with detached dwellings, and more than half of the dwellings on the street, looking at your property record cards, show 4 or more bedrooms, and the subject site has only 3 bedrooms. So really the essence of this application is to create that 4th bedroom for a growing family that wants to live here, and this will provide a needed and better living environment. Second page, we just take you to the air to see what we saw back on June 1st, just a couple of days ago. You get a sense of the scale of the home. We put the little yellow arrow on there. This is looking to the west. All of those trees that you see in the back are the cemetery. I believe there was an application for a synagogue here not too long ago. That's further down the street to the left. I don't know, about 10 or so lots to the left of the subject site. You can see that it's developed with a detached dwelling, and the home is substantially smaller than the home which is immediately to the right from this particular vantage point. That becomes evident again in frame number 3, which we've now panned to the north, so the cemetery would be on the left. You can see the larger home immediately behind the subject, and you get a sense of how the subject dwelling has a partial second story, which the applicant is looking to fill that void as we look from this vantage point. That also becomes evident in frame number 4, which is an aerial drone view of the property now looking to the east, so at the back of the property. And you see how the back of the building steps down, and the applicant, again, is looking to fill that void. And then finally, the last frame gives you a little bit of a plan view, looking at the property top down, showing where that step down at the back of the property is, or the building is. The building footprint is not going to change. The applicant is working within the confines of the footprint that's there. And interesting, the applicant is actually going to improve the lot coverage so that the site will be slightly more green than it presently is now. The detached garage in the back will stay. This is not an addition for an attached garage in the front. So the key point, again, from a physical planning standpoint, is to the extent that the ordinance protections there of FAR controls are to protect neighborhood character. What you see is substantially what you'll get from the public realm on Bodwell, and not substantially altering the character of the neighborhood from a physical planning standpoint. We've also given you some analytics based on your property tax records, and we went through each one of them. They go through sketches of all of the lots on the street. They give you information about floor by floor, what each one of those square footages are, the livable area, the area of the garages, when the structure was built, and the construction materials. So there's a good body of evidence in those property records. And what we've done is boil it down to a nice little table for the board here to show that not only from a physical planning standpoint, but from an analytical standpoint, we also have good neighborhood harmony here in terms of what the applicant is looking to do. And Mr. Chairman, with your permission, I'll mark this as A4.
Sure.
And as A4 is being handed out, I just want to remind the board that the primary reason that we're here in front of the zoning board and not the planning board is that the applicant is asking what's known as a D4 density variance. Looks like your ordinance was changed just a couple of years ago to clarify, rightfully so, that this would be properly in front of this board as a D variance, not a C variance. I think prior to 2018, you had some language that said this would be a C variance, which would be counter to the land use law. So again, the board has proper jurisdiction here. The actual number that the applicant is asking the board to move on is 42.5%, where the maximum allowed in the R6 zone is 36.0%. So that additional square footage, again, to square off and add a fourth bedroom, is the reason why the applicant is requesting that relief. There are some subsidiary C variances that are related to setbacks and the like. I'll go through that in a little more detail. But I think what's important for the board to realize is the footprint of the building is presently non-conforming in terms of setbacks. They're not far off, but they are off. And it really relates to the fact that we have a somewhat squeezed lot here in terms of its shape or its width. It's 50 feet wide, whereas 60 feet would be the minimum required. The actual lot area conforms. We do have some good case law that says when you take an existing non-conforming structure and you raise it or you extend it up, there is a pretty clear-cut basis for hardship relief, and we'll come back to that as we talk about the C relief that the applicant is seeking.
Mr. Miller, real quickly, this data you compiled from where again?
This data, I went through each one of your property tax cards, your property record cards, one by one, and I did this personally myself.
Okay.
And what you're going to see are approximately 22 rows across and then about a dozen or so columns. And we'll take you through what they show. The rows identify the property addresses of the 22 or so lots on the street. We give you the lot and block number for reference as well. And then again, going back to the property tax cards or tax records, you can see the square footage of floor number 1, floor number 2, that's indicated by columns F1, F2, and then the garage area. As I understand your ordinance, those are the areas that count towards overall floor area. I know you have a requirement as well that the attic would count if it's certain percentage, I think it's 50%, covers the floor below and is also within 6.5 feet in terms of height, which I'm told by our architect is not the case here. So we're not counting the attic space, and don't believe your ordinance calculates, or at least for the purposes of apples and apples, I did not count attic space in any of these calculations as well. So we've given you a table that shows in aggregate, or a column that shows in aggregate, the floor area of each one of the homes on the street. And we've highlighted the subject property with gray coloring, just so you know which one we're talking about. And there's a floor area of 2,644 square feet that will ultimately be what the applicant is proposing. A relatively modest expansion over that which presently exists, 729 square feet over that which presently exists. We next take the lot area of each one of the lots, and then we apply the floor area ratio calculation, dividing the floor area by the lot area. And you can see that the subject, again, is at 42.5%. If you go a little bit further down, you see I've highlighted in red that there are other lots on Bodwell that actually have more FAR than what the applicant is seeking here, ranging from 44.1% to 46.1%. Again, the applicant asking the board to move on 42.5%. Next column, we give you the year that the buildings were built, and you can see All but one or two were built in the 1930s. And then there's another column or another line item in your property record cards that talk about livable area. I believe that calculates the first floor and the second floor, but not the garage. In this case, you can see that the applicant is asking the board to move on 2,284 square feet, and we've given you two other lots on the street that actually have more livable area over on 21 Bodwell and over on 26 Bodwell as well. And then lastly, just to underscore my point that the heart of this application is to get that fourth bedroom. We've highlighted in that last column all the lots on the street that have 4 bedrooms, and there are more lots on the street that do have 4 bedrooms than do not. So
Quickly, how are you determining the difference between floor area and livable area?
I didn't cross-check how the property records calculate livable area. I can do a quick calculation, but I believe it is, again, taking floor area 1 and floor area 2 and not counting the garage area. So habitable area, and I'd have to go get my phone and do the math. If 1,118 plus 1,166 would add up to that livable area. That
What is livable area in terms of municipal land use law?
I believe it's habitable space.
Right, but is that a metric that we use for determining anything?
Maybe from a building code standpoint, from a zoning standpoint, no, it's typically floor area.
Correct. So let's jump to that floor area column
Yep.
real quick. Not to interrupt your testimony here.
Sure.
Where does your home rank in terms of floor area of that street?
It looks like, and I probably should have highlighted in red here, it looks like there's one other lot at 26 Bodwell that's 3,094 square
Right.
feet. So we'd be second.
Okay, and the lot at 26 Bodwell is how much larger than 19?
That one is 9,017 square feet.
Is the home at 26 Bodwell conforming in terms of floor area ratio?
34.3%, yes, it is.
Okay, continue your testimony, please.
So again, we've tried to give the board some rationale here in terms of analytics, how this is not going to violate the intent and purpose of the ordinance with that 36% coverage control, floor area control. Importantly, the overall height of the building is going to conform. The applicant is not here asking the board to move on any height relief. The lot itself is not undersized, so even though we are dealing with a narrow lot width, we're dealing with land area that has adequate capacity to accommodate the development before the board. In terms of parking demand, water demand, sewer demand, and the like. Reminding the board, this application is here for a family that's already here, so it's not adding additional population density to a site that is already used by the same family. In terms of the relief and the justifications, again, we're in the R6 residential district. The primary relief is the FAR, 42.5%, again, capping at 36 being the maximum allowed. The C relief, we've got on one side, 8.2 feet for the side yard setback, which is an existing condition being extended vertically. 12 feet is the minimum required. And then the side yard on the other side is 9.3 feet, where 12 feet, again, is the minimum required. Again, extending upwards above that, which is presently there. C relief for the front yard setback, 31 feet, where 40 feet is the minimum required. The architectural plans give you a good depiction of that as well, extending vertically, but not extending vertically above, I'll say, piercing the allowable height of a building. And then finally, the C relief for the lot coverage, 47.67%, where 45% is the maximum that's allowed. That's actually an improvement over the existing condition, which is at 47.95%. Taking that evidence that I've just given you, and you're going to hear some more architecturally as to how this building will flow, function, and operate safely, efficiently, comfortably, and meeting all applicable codes from a building code standpoint. Taking it back to the statute, the case law talks about a case over in Randolph Town Center that has a lesser burden than an applicant who's here for a use variance. The essence of the test is whether the site can accommodate any problems associated with that additional floor area. We always look towards the positive criteria, and here, from a planning standpoint, I think the project offers several public benefits. Home improvement in general on any home adds value and quality to the property, which in turn adds value and quality to the area if it's done tastefully. We think that's the case here. The project, as I said, will provide a better living environment for a growing family that likes living here and wants to stay here. The building appearance will be attractive. You've seen the visuals that were just handed out, and in keeping with the overall neighborhood. The addition is tasteful. It's generally modest at the back of the building, 729 square feet in total. It's not going to be overly obtrusive or overwhelming in the context of the neighborhood. The addition does not, as I said, create additional population density, and it does come back to core planning goals of efficient land use, variety of land uses, and positive aesthetics. Those are purposes A, C, E, G, I, and M in the land use law. Counterbalancing that with the negative criteria, for all of the reasons I've given, the site can accommodate any problems with the added floor area and density. Based on review of those property data cards, there are other homes on the street that have higher FAR. I've given the board 4 here. And as noted, the addition is modest and will not physically or functionally over-intensify the site. Based on all of the above, none of these variances, in my opinion, will cause impacts of a substantially adverse nature to the neighborhood or to the intent purpose of the zone plan. Lastly, those C variances that the applicant is asking the board to move on can be justified under C1 or C2. You've got both provisions in the law. It's not an applicant's burden to pass both of them. It's one or the other. Here, I think we're actually double strong because we do meet both tests, in my opinion. In terms of the C1 hardship, all relief relates to the land, narrow lot, and the structures that are lawfully existing thereon. That building footprint is there. The setbacks are presently non-conforming. That's practical difficulties in the true context of the ordinance for an otherwise ordinary sized home in the district. As I said, the home is already there. The setbacks are merely extensions of existing structures. And just to put it in the record here, there is a case, the Harley-O case, which the court found a similar basis for hardship relief that actually pertained to a barn that was being extended vertically. Also, we could turn to the C2 balancing test, where we look at the benefits of the application as a whole, taking a building that's there, trying to modernize it in a sensitive manner consistent with the neighborhood. The benefits of the application substantially outweigh the detriments. All of those D benefits that I just gave you would carry forth to the C aspect, and that's the Pullen case, Pullen, which says look at the application in aggregate. So in that regard, I believe all C relief is necessary to effectuate a good project, and will, other than the fact that strict enforcement of the ordinance triggers relief here, I think the spirit of the ordinance is met, that this is not going to over-intensify the site or cause substantial harm to the neighborhood. With that, Mr. Chairman, I would just close by saying the statutory criteria for both D and C relief are met. And in my opinion, approval is warranted. I know we still have another witness to go, so I reserve the right to come back if something pops up during his testimony.
Real quickly, Mr. McDonough, how are you achieving your lot coverage reduction?
I'm going to defer to the architect in that regard. You're not up yet.
Any other questions for Mr. McDonough from the board? Any questions at this time from the audience for Mr. McDonough? Okay, you're next.
Now you're up.
Professional.
Do you swear upon testimony about the given next proceeding be the truth, whole truth, nothing but the truth?
I do.
Your name, the record spelling.
My name is Haik Ekshian. Last name Ekshian, Ekshian. First name Haik, Hayk. I'm the architect for this project. I'm a licensed architect. My license is current. I've appeared before this board a few years ago, and I've appeared on many other boards in other towns.
Your education?
I'm graduated from New Jersey Institute of Technology with a Bachelor's of Architecture.
Thank you. Your credentials are accepted. Please proceed.
Okay.
Can I bring this close?
Sure.
I think my client did a good job explaining the project last time. We're
Do we have this already? This was submitted?
Yes, this was submitted. It's the same plans which you presented. And our addition, we're proposing to add towards the rear yard and adding an attic space to add an additional bedroom and bring the house to modern day standards. As you can see, the floor plans, it's a very efficient floor plan. And on the first floor, you have a family room, kitchen, open concept. From the rear, we have a mudroom, pantry, powder room. There are no hallways. Every room is flowing one into another. And a dining room that's set to the side and a study room. On the second floor, we're proposing 3 bedrooms. There isn't really more space left. There's a hallway bathroom for the 2 bedrooms and a master bathroom for the master suite. From there, we're adding to the attic space, we're adding another bedroom and a bathroom and a playroom. In the basement, we're renovating it. It's the same footprint. We're adding a rec room, wine room, storage, mechanical room, a bathroom, and laundry will be located in the basement. I understand, I listened to the testimony last hearing, and I understand the concern was about the bulk of the building. And we prepared 3D renderings to give you a sense of what the addition is going to look like from the front and the rear. Just want to go through the elevations quickly. I feel like they explained the addition a little better. In the front, most of the house is remaining the way it is. There's going to be new siding, new roofing, new materials. We're adding, if you can see on the side elevation, this dash line is the existing outline of the building. And we're adding towards the back of the building. The roof is being extended about 5 feet, and then the remaining addition is in the back. We're adding this dormer in the front, which improves the aesthetics of the building. Instead of having a plain roof, now with the dormer, it's going to look more pleasant from the street. And this is the rear elevation and the other side elevation, as you can see. Here are the renderings of the rear yard. This is the current picture of the house from the rear. As you can see, it looks much smaller than the 2 other neighboring houses. It is smaller, and our addition gives you a sense of what this house is going to look like, which is pretty much similar size to the homes on either side of the property. It's not going to be domineering. It's just going to fit right in. And from the front, this is the current picture of the house, and our addition. You can't even tell the addition without the from the front. You can see the dormer added, but the remainder of the addition is just from the front. It's just these 5 foot of top of the roof that you're seeing. This is the garage in the rear, and this is counted in this whole FAR, the bulk of the building. This is 360 square feet. If you were to take that garage out of the equation, we would be only asking for 0.74% FAR variance. The reason I'm bringing that up is also the garage, significant amount of the garage is underground. The back right corner of the garage is about 6 feet below ground, and the back left corner is, I believe, about 7 feet underground. So I wanted to give that as a reference to tell you that the significant portion of this box that we're counting in this number is also below ground. With that, I'll conclude my testimony and take any questions.
Any questions from board members?
Quick question, what is this dormer, what is behind that, if you could just refresh
Yes.
my memory, what's in the dormer?
In that dormer, we're proposing to put in it's really a nook for the bedroom, just a study area, and a bathroom for that bathroom.
So I know
For that bedroom.
Thank you.
Any other questions from the board?
When you say the floor of the garage is underground, does it slope down when you go in?
The land slopes up as you go towards the back, and the front of the garage is at grade level, obviously, but the sides, the land slopes up significantly. So the back of the garage is, if you look at the topographic survey, it's about 6 feet, 6 to 7 feet below grade.
Oh, below grade.
Yeah.
So the floor of the garage is level,
Below grade.
below grade but
Yeah.
level.
Yeah, level.
When you were designing this, what measures did you, or what did you do to consider trying to make this fit within the FAR?
We looked at various options, and given the program that the family needs, and you can see that we have designed the layout very efficiently. We didn't have many choices, but except we had to go over the FAR to put in the additional bedroom.
To make the fourth bedroom?
Yeah, exactly.
Any thought of reducing your scale on the sides in order to make this more comply with your side yard setbacks?
The side yard setbacks from the side. Well, you can see that.
For the second floor, I mean.
Right, as soon as we start eating into the building, we start losing the master bathroom. Perfect, I would say today's standards, you need 4 fixtures. It's a 5-foot double vanity. It's modest size. Next to it, we placed a tub and a toilet and a shower. As soon as we start shrinking it, we're going to start losing plumbing fixtures, and it's going to, I think, negatively affect the aesthetics of the house. And also, it's not going to make a large impact to the FAR taking 1 foot or 2 feet from the sides.
Just a follow-up question, did you consider at all looking at the scale of these are quite large bedrooms.
Right.
Did you consider looking at that in the design of this?
Most of the house is fitting within the existing walls. We're not making any changes on the first floor here in the basement. Really, the back portion is what we're adding here.
The bedroom in the back?
Yeah, the bedroom in the back is the addition, and we're talking about setting back a foot or two. In my opinion, I think we have a 17-foot by 14 feet bedroom here. This is I would say a standard size master bedroom, and if we were to shrink it another foot or two, I think it's going to negatively impact the design, and it isn't really giving us giving back enough FAR to justify the just a couple of feet there.
Any other questions? Any questions from the audience? Any other testimony? Do you have any other testimony? Then I will open up to comments from the audience. Anyone in the audience have a comment regarding this case? You through, Mr. McDonald?
I just had one quick thing, Mr. Chairman, just
Sure.
learn from Mr. Skolnick back there when I need to intervene. An important point, which I don't know if it came across to the board during Hike's testimony, if you look at the column with the garage, it's the biggest garage on the street. So that's going towards this calculation of FAR and why we're at 42.5. If the garage wasn't counted, I know it counts, but if it wasn't counted, we'd be at 36.7. Your ordinance is 36%. So again, if the garage went away, which we really don't want to do, 36.7 is what the home is.
Can't do that either. So, yeah,
Gotcha. So anyhow, I just wanted to underscore, if you go through that column, this is the largest garage on the street. So it does impact the FAR.
Thank you. Mr. Skolnick, feel free to send me a bill. Yeah, that's right. Any other comments from the audience? In that case, I'll close the public portion of the case. Board members, what are your thoughts? All right, I'll go first.
Yeah.
So this is troubling, the size of the FAR deviation. You know, when I look at the four houses that are, so we see, more substantially over on this block, they are well below the standard in the lot size. So, you know, they are all below. So one at 4617, which is substantially below the 6,000 square foot, 52, 5,400, 5,400. Now we shift to this lot that's over. So even if we apply this, I have a big garage theory, it's still 218 square feet over the standard. So it's a large deviation. So I'd be interested to hear what my fellow board members have to say. The other thing that is concerning is this, for me anyway, is the side yard setback. That typically when you have a house that is substantially over FAR, the massing gets to be an issue. So when you see these houses that are this much over the FAR, you almost look at it and say, that house is probably over the FAR, because it does have a very blocky, big look from the street. So I am interested to hear what everyone else has to say about this.
I mean, I agree. Did it help you to see the renderings though, which we didn't have for, because that's the one thing where I look at it and I'm like, where I would expect to see it looking like overpowering with that FAR, that, you know, then I look at the renderings and I'm like, it doesn't look as overpowering as I would think that it would. So just curious what.
Public portion is closed.
Yeah, no, I agree with that. I was concerned about how it would appear, but it does, you know, I don't think it seems to be overly masked in a sense, but I take your point.
Yeah, I hear what you're saying, Greg, about the degree of FAR overruns, but it is a thoughtful, tasteful addition to the neighborhood. I can see where most of the addition is going to be in the back, which I appreciate. I'm a little more concerned about the dormer, which adds to the massing effect, I think, for me. But it does look like they've taken measures to be conservative with some of the addition, at least except for the dormer.
Any other thoughts?
I'm just saying, I agree with frankly you and Jessica. Like from a chart perspective and just pure FAR is the concern that I have. And you're absolutely right, Craig. But I also looked at the rendering and if the massing of that, and it seems not overpowering. So I'm kind of on the fence.
I'm just concerned with that is what it's actually going to look like.
Well, right, the renderings never
Right.
exactly. I know.
So that's where when you see this angle of it,
It's the rear too.
and it's also the side. I mean, when you take two homes that are next to each other of that scale, it's going to have a very big canyon effect between the two homes because they're so close and so high. So I would take that with a grain of salt. So in that case, do I have a motion?
Can we open it back
Absolutely.
to the applicant? Just, I listened to the tape from the last meeting, and not that anyone was necessarily suggesting this, but there were no changes made to the application. This was really more of just a more in-depth presentation. I'd ask the architect, any way that you could trim down?
Can I have a motion to open
Sorry.
the meeting?
Make a motion to open.
Second,
Second?
all those in favor?
Aye.
Aye. Mr. Leon, the public portion is open, so if you would like to speak, please come up though.
Right, so the only point I wanted to make, when you were looking at the rendering, you said it doesn't look as bulky or anything like that. The portion in the back, this addition, actually conforms to all the side yard setbacks and everything. This overall structure conforms to all the setbacks, roof slopes, everything.
What's your second floor where you're having a problem?
No, not this piece. The FAR,
On your sides, where you're.
the sides that are in non-conforming are on the main part of the building, but this little added piece, and that's why it doesn't look like some big giant block stuck on the back of it. I could build this box according to the code, just not put the second floor in, make the kitchen a cathedral, and I would conform. All we're asking for is to fill that area.
Right, it's the FAR. That's your-
Correct. Yeah. So that's why the addition doesn't.
Well, actually, the new ordinance wouldn't allow you to do that either. You couldn't build a cathedral ceiling because the cathedral then also counts towards FAR. But
It's again, we're just we're not trying to add a lot, right? We just wanted to get some more space. The question to Hike about the layout of the plan, I think I said this at the last one. I mean, I've spent the last 2 years staring at this plan and living in the space, and it's just such a tight space. You start losing things. You start losing. You want 3 bedrooms, 2 bath on the second floor, so that it's functional for a family.
we understand all that.
Yeah,
So,
so-
any other questions or anyone else
No,
have any
it's
questions
just
about the public
curious.
portion still open? Then I'll close it. So with that, I hope the question was answered. Oh, sorry.
Actually,
Did you-
have a chance to answer.
Did you have any comment? To
The
question that was
architect
answered.
in just in response to.
consulting with my
yeah.
client.
Oh, go ahead.
To see how. I don't have a comment. I think this is the best we're going to come up with.
Okay. Do I have a motion?
I will make a motion to approve.
In a second?
Second.
Nancy Abigail,
Yes.
Dave Lawrence? Yes. Karen Rosen,
Yes.
Regina Truitt,
Yes.
Joseph Caulfield,
Yes.
Jessica Black,
Yes.
Craig Plainville.
Yes. Good luck with the project.
Thank you, guys. Means a lot.
Next up, we have calendar 39/18/23. This was carried from 4/17/23. Danielle, 20 Claremont Drive in Short Hills.
So just for record, we decided that I'm going to say that you do not listen to this,
Which one is this, sorry?
this matter. 17, you do not listen to
Was it in the same meeting?
Is that applicant here?
Like Claremont? Like Claremont?
Anyone here from 20 Claremont? I'm sorry?
Like tonight, you have the day?
Why don't you come up forward? Come on down. Step in front of the microphone for me, please.
Sure.
And just voice your intention so we have it for the record.
So our intention is to come back with it.
Okay, and you are?
Thomas Singer, architect.
And my name is Gang Yang. I live at 20 Grama Drive, Short Hills.
Okay, thank you. So Eileen, when can we hear this case?
7,
I'm sorry?
August
August
7.
7th. How does that work?
Sounds good.
Okay, there'll be no further notice. It will be published in the website, in Town Hall. So thank you very much.
Thank you.
Moving right along. Next up, we have calendar 39/20/23 to Brentwood Terrace. Bharat Sadula.
Do you swear or affirm the testimony about to give tonight is the proceeding of the truth, whole truth, and so truth?
I do.
Your name and your name for the record.
But it's Sadula to Bradford Terrace. Sure.
Good evening, Mr. Sadula.
Mr. Chairman and dear members of the zoning board, a very good evening to you, all of you. My wife Deepa and I are the owners of 2 Brantford Terrace.
Excuse me, swear in there?
Yes.
Yeah.
We did?
Yeah.
Sorry.
Sure, no worries. I just wanted to let you know that as our family has grown, we've felt the need to expand on the current dwelling structure. However, as my architect Greg will point out and elaborate in further detail, the current topography of the property has significant challenges and presents restrictions in terms of the expansion of the property itself, expansion of the dwelling structure itself. Therefore, we are seeking relief through this variance application process and from the front yard setback as well as the side yard setback and some of the building height requirements. I would like to point out to the board that this lot, which resides in the R3 zone, is undersized, is irregular shaped, and has substantial topographical challenges, as well as a sunken driveway. I've discussed the variance application with my neighbors, 2 of my neighbors, as well as sent written notices to the members of the 200 list. Neither of my neighbors nor anyone else has come back and expressed any concerns with respect to the variance application itself. So I will now hand over to Greg, my architect, to elaborate further in terms of the current setbacks of the property, as well as the proposed additions, alterations that we are planning on, the topographical challenges that are present with respect to the current property, the lack of viable alternatives with respect to the plan, and the details of the variance that we are planning. Thank you. Thank you for hearing
I
me.
just have a quick question for you. Are you currently residing at that house?
I'm currently not residing at that house. Yeah, thank you. Any further questions?
Nope.
Do you swear or affirm the testimony about to give tonight's proceeding to be the truth, whole truth, and so truth?
I do.
Your name for the record.
Gregory Ralph, last name R-A-L-P-H. Do you need the address for the record?
Yeah, please.
1924 Route 22 East, Bound Brook, New Jersey, 08805.
And your credentials, sir.
Sure. Bachelor of Architecture from Roger Williams University, licensed in New Jersey since 2011. Very versed in residential design and construction, and have testified before a lot of boards around here, Chatham, Summit, Westfield, etc.
And your license is currently in good standing.
It is.
Please proceed.
I have one point that I believe might be for the board attorney as we get kicked off to keep things exciting. So in my preparation of the testimony tonight, it came to my attention that the garage setback from side yard is existing non-conforming, and we have a small addition to it that would also be non-conforming. And that, while I know the noticing has covered any variances or waivers that come up during testimony, but I just wanted to address that up front because I'll testify to it. but I wanted to raise and see if that's an issue with proceeding.
How's the notice given? Is there detailed setback numbers in the notice?
No, it was the, just general references, like maximum height, or, that's how we did our notice.
They noticed, side yard setback, building height, front yard setback.
This is,
Side yard setback.
this is a subset of that side yard setback criteria. It's just as it relates to side-facing garages. But again, I want to be clean and clear on the record.
You're adding to the garage?
We're adding 2 feet to the garage, correct? It's less encroaching than the existing condition,
It's still not 20.
but it's still not 20 feet.
I believe they advertise side yard setback, and there's also in their advertisement that there other variances can come up. I believe the board's jurisdiction. It's your.
Very well, will be the case.
Okay, appreciate that. Thank you. So we're here tonight for a couple variances, which I'll summarize, and I'll walk through the lot and our proposed conditions. So I'll just restate them for the record. So we have 2 front yard variances where 40 foot is required by ordinance and the established setback is 53.69 feet. We have a proposed condition on Brantwood of 43.8 feet. And we have a proposed condition on White Oak of 41.3 feet. So both of those, while they comply with the 40-foot setback, we do not comply with the established pattern. And I have up here a drawing prepared by Morgan Engineering, but in coordination with my office, and that was part of the submission. I will reference that for a significant amount of the initial testimony. Then we have a side yard requirement of 18 feet for a 1-story or 25 feet for, 15 feet for a 1-story or 25 feet for a 2-story structure. Our existing abutting this neighbor is 8.37, and we've made a minor improvement to that condition to 9 feet, and that's a 2-story portion of the dwelling. And then we have a maximum building height required of 32 feet average, whereas our proposed is 33.6 feet, so 1.6 feet over, which I'll get into. I believe that the initial denial and documentation had a reference to a fence variance in the front yard. I don't believe we're asking for a fence variance in the front yard because it would be a decorative 4-foot fence on a county road, but I definitely want to clarify that point because that's what we show outside of the site triangle, abutting White Oak Ridge Road. We have a 4-foot decorative fence.
Yes, White Oak County. I don't think it was noted on that.
Is your fence in the right of way? I'll wait till I'm drawing this map. It looks awfully close to your line.
It's within the,
It's
Within the bounds.
it's on our side of the property line by about 1.5 feet, if that's the question. And again, it would be 4 foot, it would be decorative, and it would have the plantings that are part of that ordinance provision. So I just wanted to clarify that we're not asking for that fence variance. And then lastly, the section for the garage setback is 606.2E, 1E, 2C. And that's the reference where a side-facing garage facing a side yard must be 28 feet from the property line. Our existing condition at this inside corner is approximately 20 feet. And the outside corner where our addition is 23.8 feet, where 23.8 feet, where 28 feet is required.
your ordinance does also say, it says to accommodate the 23-foot backup and the required 5-foot driveway
Buffer,
setback,
correct.
which you don't have. So it does have the 23, the technical backup.
Yeah, our addition has the 23 foot for the maneuvering of the vehicle. And as I'll testify to, that driveway is both an existing and a proposed condition. So we're not able to physically improve on it based on the proposal you have. All right, I'll dive in. So it is an R3 lot. The lot is non-conforming in 2 key ways. The lot area required is 29,000 square feet, where we have 19,034. So we're about 30% undersized in terms of lot area. Our lot width, which is measured on the Brantwood Terrace face, is required to be 115. Our existing is 106.6 feet. And I do want to highlight, because it's not evident, I don't think, that the lot tapers down to 64 feet on our south side. So pretty significantly undersized in terms of the lot width, which directly affects why we're here and what we came up with. And then the lot is currently developed with a 1.5-story frame and masonry dwelling. A unique feature of the site is that we have this driveway that enters off of Brantwood, and it enters at an elevation that meets the street at that point, and it stays at a relatively moderate gradient to this existing basement level garage that is that side-facing garage. And that's a condition that we inherited, and as I go through the plans, I'll show that we keep that, maintain it, and improve it. There's also existing retaining walls that separate us from our neighboring property, which we intend to keep and or improve on. The key point that you'll hear tonight is that once we were engaged by the applicant, once we understood the site complexity, we worked to maintain or improve the condition that was there on the lot, because based on the undersized nature of the lot, the shallowness of the lot, and the very unique topographic condition, which I'll speak to, there was not another place to build this conforming mass. So even though we're an undersized lot, the FAR, the building coverage, and the lot coverage all conform, even at that undersized lot size. That was really important to us to maintain that conforming massing and size of development. And then the trade-off here was that we were building over the existing foundation and basement wall and then expanding that forward to accommodate the design requirements. And so we were maintaining that side yard setback issue, and we slightly exacerbated the front yard issue. All right, I will switch to plans. So I'll start on V3, which is not altered from the drawings that were submitted that you should have in your packet. And I can come back to this site plan if I need to answer questions. So I'll just go briefly floor by floor. I'm not going to go through the whole floor plan arrangement. I'm just going to go by the key factors that relate to the variance. One of the things we did that we hope proves helpful is there's a red dashed outline on each floor plan that represents the existing home's footprint.
And that's not on ours, correct? This is what we see.
That should be on, that red dash should be on yours, yeah.
Got it, thank you.
Yeah, no problem. So what you'll see is, as I mentioned in my kind of initial intro, that garage, as it relates to the existing driveway and the existing topography, was our hold point from a design perspective. Trying to alter that driveway access from the street, altering the topography, sliding the house more towards the street was not feasible based on topographic constraints. So we held the driveway where it was. And as such, you can see that that portion of the wall is actually the existing garage wall to remain. Same elevation, same slab height. We will obviously refresh it. I'm not saying we won't, but we kept it in its same position for access. And then we kept that back corner of the house as well for the reasons I said, that it's quite infeasible to move towards that hill without disturbing topography and steep slope. To reconcile the massing a bit and to avoid an FAR issue, we actually cut in that, what is the south side of the house, which you can see these voids, by about 4 feet. So again, I'm just trying to make the point that we were trying to balance and keep all conforming coverages and FAR. We cut that in, and that's why the setback condition improved from 8.37 to 9 feet, because we're sliding that wall over slightly.
So what are you preserving of the existing home exactly?
It's primarily the foundation wall in that area.
Just that one wall,
Correct.
essentially, what you're preserving. But essentially, this is a new build.
Essentially.
Okay.
It's an expand, right, exactly. It's an expansion. You can see where the foundation wall is there.
Right.
And the elevation and the site.
Yeah,
is remaining.
but the physical plan is essentially all new.
Basically new, correct.
Got it.
So there's not much more that I need to talk about in the basement area itself. It's going to be a 3-car garage and then typical basement amenity with 1 bedroom. The house has a total bedroom count of 6, but it's 1 in the basement, 1 on the first floor, and 4 on the second floor, just for count. So the first floor is a relatively typical arrangement. The White Oak Ridge Road is at the top of the page. So they are going to maintain a front facade presence toward White Oak Ridge with a secondary facade presence towards Brentwood. And again, a relatively typical arrangement you would see with the typical living spaces and amenities, kitchen, living, dining. And then there is an office and a guest bedroom on that floor. And again, you can see where that wall was pinned, and we kind of took away from that south side and grew towards White Oak and Brentwood. Again, I'm just going briefly through the plans because that's not really the meat of what I'm trying to get at. And then the second floor has that sitting area when you get to the top of the stairs, and then 4 bedrooms kind of off of the central core. This bedroom 1 would be the encroaching bedroom from the side yard setback perspective. That's built on top of that existing foundation wall and at that existing point. I'll just switch to, and then I just want to make a summary of all the reasons and answer questions. So on V8, I'm going to switch over to V8. This is the section that's at the 9 feet towards the neighbor. The grade tapers down, so that the heights vary. So at the left side, we're at about that 26, 27 feet to eave height, but at the right side where it abuts the rear yard, we're at a 19-foot eave height. So I'm just putting in perspective the height of the massing at the side yard. And I'll come back to the side yard again in a minute. The main ridge height you can see noted on here. So that ridge height is a little less than 8 feet above the bottom of the eave, meaning proportionally I have from the underside of the gutter line to the top of the ridge, I have 8 feet. I bring that up because I know we have a height variance, and I know a question might be, well, did you explore reducing the ridge? And my answer would be that we did, and when you look at it as a story height to story height and just general visual proportion of roof to the rest of the house, keeping that roof high enough at that 8 feet that I could have some gables on the elevations and give it some presence was important from a design perspective. All right, I'm going to just run through the reasons that I have for each of these, and then I'm happy to answer questions. So when we look at that front yard setback issue on both sides of the house, I'll flip back to the site plan. If you look at the grading plan, even the existing grading plan, there's a natural plateau in the area of the existing structure. And there's not a lot of distance between the existing structure and the edge of that topography that happens quite quickly. We have anywhere from a 15 to a 20-foot delta from the street to that plateau. So it's quite significantly above. And as you can imagine, development there would just be kind of illogical and infeasible. So we are bound by that plateau. We had a little bit of room to work with, so that's why I said we built out about 2 feet towards Brentwood in terms of our expansion of the existing structure, and we built about 6 feet towards White Oak Ridge. Again, occupying that plateau, trying to work with conforming coverage and filling that plateau space. The topography itself is going to kind of self-screen us from White Oak. What I'm saying is, in other words, I don't feel that we're too close to White Oak or too close to Brentwood in terms of the massing. We're still beyond the 40 feet. And as I said, we're over 15 feet elevation above. It's a county road. The cars passing by are not going to feel us as being on top of them in terms of massing and structure, as we have that delta of grade. In terms of the building height, it also relates to the topography itself. As I mentioned in the beginning, we have that existing driveway. We're preserving that for how it connects to the existing road at Brentwood Terrace. The garage under penalizes us in terms of the ridge height. If we did not have the garage under as part of that calculation, we would be a conforming ridge height. I say that to say the structure as viewed from Brentwood and White Oak would have the conforming ridge height measured from the grade that is visible up to the ridge. So we were very conscious of that. Where we lose the ridge height is when we add in the average grade calculation around that backside of the building. And as I mentioned, we did not max out the height of the portion that's encroaching on the side yard because we were conscious of the presence of that massing in the neighbor's view at the 9-foot setback. In terms of the side yard setback itself, when you look at the buildable envelope, which is on this, and I'll point out that the buildable envelope that's dashed on the plot plan is with the 40-foot setback, not the average 53. So if you show the 53-foot, it's a generally unbuildable lot. And the point being there that really any development on the lot, unless it were to be a quite interesting shape or a very narrow structure, any development on the lot is going to require a variance in some direction. And the case that we're making is that based on the topography, growing any farther towards White Oak or Brentwood is not feasible. And so maintaining where the house is and has been at the 1.5 stories and just bringing it up to a 2.5 story seemed like the most reasonable approach. One thing that's probably not evident here and may not be evident in the photos, but we did take some measurements, is that this portion of the neighbor's lot is their driveway. This neighbor has a side entry garage, so their vehicles are turning this way. They have what appears to be very close to a conforming garage setback. We measured it on Google Maps, we took some photographs. I'm not going to certify the exact distance, but it's at least the 25 feet away. My point being, when you combine their amount of open air and space with the 9 feet that then tapers back to more distance, this could be acceptable and approvable. In that this is a well-developed lot currently. If you've seen that structure that's here, and with that driveway access there, it's unlikely that that condition will change. Therefore, you're not approving what was mentioned before as a canyon between two properties. There will be adequate air and space, and because we're abutting their driveway, we're not abutting a recreation space, we're not abutting a developed yard area, we're abutting pavement. So I did not think that was totally clear in the provided documents, and I wanted to point that out. And then the last comment on the side yard is it's divided currently with an existing retaining wall, and the neighbor has an existing fence. And this height differential here, this wall is 6 feet high. So from our driveway to their driveway, 6 feet, and then they have a fence on their side of it that I believe is 4 feet high. And there's some existing planting. It's nothing I'd call true screening. So that's really it. If we're going, I don't know if I'm allowed to talk about C1 criteria as an architect. I don't know if you accept that, but if I was putting that forth, I'd say that we would be applying as a C1 because we have the 3 things that are there: the exceptional narrowness, shallowness, and exceptional topographic conditions on the property.
Can I ask a question?
Yes,
Real quick?
sure.
The proposed retaining walls on the Brentwood side,
Yes.
they are how small? More than 2 feet? I don't see top wall, bottom wall in one spot.
It's 2. Yeah, the top wall, bottom wall was 105 to 103 right at Brentwood. That's 2 feet. They do increase.
Because here they indicate they're 2 feet. but
Yeah, they
the
go.
height seem to be much lower. Restricted to 2 foot wall. Is this, are you, well, you're replacing the time, but that's all.
That one wall is probably what the 6096A was for, because I know that 6096A in your ordinance also refers to retaining walls in the front yard. So and I apologize for that. So when we revised the fence to eliminate the fence variance in the front, this retaining wall height is technically in the front yard, which is what you're clarifying. So that wall has to have the height it has, so that wall would meet the variance.
What is that height?
It varies. Yeah, at the house, it's 5 feet. Over here where the stairs are, it's 4.4 feet. And then where it's at Brentwood, it's 2 feet. So it kind of tiers up towards the house. It's not on my plan, but on the engineer's plan, they have the top of the wall and bottom of the wall, all along that wall.
Well, the second one that's not noticed, it's more than twice the height. It's in the front yard. And
I think that, well, let me check that. Let me just check before I speak.
It's in the same ordinance section, but like, at the time that this was agreed, there was a fence in the Brentwood front yard,
Correct,
which is what I.
which we removed, correct.
You know, the existing one was shorter than 2 feet, which would be allowed to be replaced, but he's actually
Building new ones.
pushing them.
It's a new wall,
It's a brand new wall.
The retaining wall is the concern.
that's the concern. It's also the second variance, it's not called out.
Is there anything that can be?
Conform.
I mean, the short answer is yes. I'm not the grading engineer, but he would roll the grade back. So it's like a, not berm, but he would roll the grade down and reduce the height of the retaining wall. It's possible.
Separate them.
Right. By what distance?
If there were 2 foot walls, they have to be 2 feet between the walls.
That's what we're doing. Okay. Sound good?
There you go.
If this
No
is,
variance.
if this is approved, that would be a condition of approval.
Fine. I'm not gonna, yeah, fine. The 2 foot, two 2-foot walls separated by 2 feet is probably the most realistic solution because we have a delta of 5 feet here. So then we don't have to do anything wild with the grade, but I am certain that we can accommodate that 100%. Thank you.
Noted. Any questions from the board? The architect?
My other question, I'm sorry, you said you removed the White Oak Ridge Road fence.
Well, did they remove it or you just?
We
reduced it?
altered it to be out of the site triangle. We don't have it on Brantwood, and we're keeping it at 4 feet in decorative, which I believed.
Right, okay, no board on board.
No.
Specifically referring to the fence that comes from White Oak Ridge Road toward the house. How tall, that can only be 4 feet.
This way?
Yep.
It would be 4 feet within the front yard, for the record.
Your side yard setback of 0.63 feet. Take that real quick here.
How we improved it by 0.63 feet? Is that the question?
Yeah,
Because we're asking for not, yeah, it's a good question. So the house as cited existing is on a very slight angle from the property line. And because we demolished a portion of the house, the lot line is farther away at that point.
Just at that
So,
point.
exactly.
Any other questions from the board regarding this?
How far away is the fence from White Oak Ridge, the portion that is being kept?
2 feet. 2 feet away from the property line, as drawn. And it would be, it's required to be landscaped and to feel correct, and we would conform to that.
So behind the fence, there's.
On the White Oak Ridge side, we plant to screen the fence.
So behind the fence, there is still 2 feet of area, which is the property line, which is
Exactly.
within the property line.
That's correct. And that would be small plantings. And then this is, it's honestly, I know it's not a variance, but it's primarily just for safety. If there's kids in the yard, that they don't, that's a steep.
What's that fence look like again? It's you say decorative, but is it
It says
a
just
state
wood.
fence or just wood? Yeah.
So it's not-
Yeah, a wood that's not board on board. I honestly don't know the final fence design, but if you approve, we would submit it.
Any other questions from the board? Any questions from the audience regarding this application? Any comments from the audience regarding this application? That'll close the public portion of this application. Board members, your thoughts?
To get started, I think that the striking thing to me, just from a primitive viewpoint, is that it is a massive increase in the appearance of the lot. The current house is very small and conservative, and this is a very large home, which of course is generating all of the need for relief. It's just a big change.
I'll say that there are certainly challenges with the lot. topographical challenges, the width of the lot, this undersized nature of the lot, but I think, you know, that given those challenges, they've done a good job of trying to, you know, build that, you know, they haven't gone beyond FAR, they haven't, you know, exceeded lot coverage. I think they've done a pretty good job of trying to make this work with the site that they have. I do have, you know, when I look at the massing of the house, it does look ginormous. It's also fully wooded in front of the house, so I'm a little mixed about that, but I'm a little on the fence, but I probably would support it.
I'd agree with everything you said. You know, but there's very little of the house that's causing the problem. You know, we have no FAR, no lot coverage. It's strictly setbacks. And as you noted that, you know, the height's another thing. It's once again, it's topography. It's very hard to get around this. And like I said, unless you want a house that's going to look like a flat roof. I mean, it's really mostly inherent to the unusual nature of the lot.
I would also have supported given the non-conformity of everything. And I think, from the design perspective, I'm also okay with the roof, 1.6.
So if we have a motion in this case, we would include the stipulation regarding the wall being 2 feet high, separated by 2 feet, another 2 foot wall. So that would be a condition of approval. If someone would like to make a motion.
Obviously, we want to just verify the fence will be decorative, will be wood.
Yeah, as
4
mentioned,
foot.
right, as mentioned, right, and obviously in conformity with setbacks and right of way. Because I don't think you want to dig that thing up. So, do I have a motion to that effect?
I'd like to make a motion to approve this application as amended with the conditions aforementioned on the wall and the fence.
I can second.
Second, thank you, John Drew.
Yes,
Yes.
Shonda Rajani?
Yes.
Andy Warren? Yes. Gary Oldman?
Yes.
Suzanne Stewart?
Yes.
Jessica Glad?
Yes.
Nick Whitney?
Yes, good luck with the project.
Thank you for your time.
Thank you.
All right, moving right along. Next up, we have calendar 392323, Citizens Bank, 101 JFK Parkway. Good evening.
Yes, Clara Horelick, Law Office of Clara Horelick, LLC, and I represent the applicant, Citizens Bank. And I promise I'm gonna be a lot shorter than all the others that have preceded me.
I like that.
Anyway, as I said, I'm appearing on behalf of Citizens Bank. This is for variance relief in connection with a wall sign on property located at 101 JFK Parkway in Short Hills, New Jersey, known as Lot 3, Block 5302, which is on your tax map in the township of Millburn. The subject property is located in the OR1 zone district. The applicant is a tenant at the subject property. The owner of the property has, of course, consented to the application. Further, the applicant leases the majority of the building, and this serves as its New Jersey corporate headquarters. As such, the tenant's lease also allows for the proposed wall sign at its proposed location, as long as that's approved by the board. For a little history, because I think this is important here, Citizens Bank recently acquired Investors Bank. And as a result of that, the Investors Bank wall sign that was on this building, the subject property, was up there from approximately March of 2019 through February of 2023. It has now been removed because of the acquisition. I was actually the attorney here before the board when we sought the sign for Investors Bank. The plan is to erect the Citizens Bank sign in the exact same location as was the Investors Bank sign upon the approval of the board. On March 4th of 2019, the board had approved in a memorialized resolution the granting of this variance relief to Investors Bank to erect a wall sign that had a graphic height of 4 feet 6 inches above the 6th floor. There are 2 variances being sought by Citizens Bank, which are the same 2 variances that were sought previously by Investors Bank, except that the Citizens Bank sign is actually just slightly smaller by a few inches. The first variance is under section 609.10A of the Township Zoning Ordinance, which permits a maximum wall graphic height of 2 feet. The applicant's proposed wall sign has a 4 foot 3.5 inch height. Again, as I stated, it's slightly smaller than the sign that was there before. The second variance falls under section 609.10D4B, which does not allow wall signs to be mounted above the 2nd floor line or the roof line. The applicant's proposed wall sign would be mounted above the 6th floor, but not above the roof line. This is the location where Investors Bank had its sign. The proposed wall sign is consistent with the Citizen Bank corporate branding, and we have a representative here from the bank that will speak to that. As well, I have a representative here from the sign company that will speak to the details of the wall sign through his testimony. It will be shown, I believe, through the testimony that the size and location of the proposed wall sign is necessary for visibility and identification. A conforming sign for size and location would not be visible by motorists or pedestrians from the main roadway, which is JFK Parkway. And due to the setback of the building and the trees, it also would not be visible. Lastly, the proposed wall sign is in proportion to the facade of the building. So, the testimony that will hopefully be presented this evening is expected to support the need for these requested variances for the wall sign under the circumstances that are unique to this subject property. The testimony is also expected to further show that the granting of this relief would permit the proposed wall sign to be up with no result in a significant detriment to the public good, nor would it substantially impair the intent or purpose of your zone plan or your zoning ordinance. I would like to introduce who's going to be appearing and testifying tonight on behalf of the applicant. Jason Backrack is from Citizens Bank. He is a vice president, and that's vice president, senior sponsorship manager. And Pierre Galinas is from Philadelphia Sign Company. He is the senior project manager and account lead for Citizens. So without further ado, I would like to call my first witness,
Sure.
which would be Mr. Backrack.
Raise your right hand, please. Do you swear or affirm the testimony about to give in tonight's proceeding to be the truth, the whole truth, and but the truth?
Yes.
Your name for the record, spelling your name, please.
Jason, Jason Backrack, Bacharach.
Thank you.
Good evening.
Good evening.
So Mr. Backrack, I just wanted to let you, I would like you to just tell the board, you used to be with Investors, you're now with Citizens. Just tell them about the branding of the signage and why this obviously application is here before us and the significance of the sign for the bank.
Real quick, your role in the bank?
I'm the vice president of sponsorships. So I manage the sponsorships here in New Jersey. As our attorney just said, I was with Investors Bank. Prior to the acquisition, we were acquired by Citizens in last year, and the sign came down, and we're looking to put the sign back up on our corporate headquarters. It's going to remain the corporate headquarters for Citizens here in New Jersey. The sign is consistent with what we've done in our branches and in other locations throughout the state in terms of the color and the conformity for consistency, with our overall branding. So nothing new kind of on that spec, if you will. And in terms of the building itself, it's, a replacement. It's the same size as a little bit smaller. In essence, Pierre will talk about the illumination and how that's going to work. So just consistent with with what's been there before and placement of where it's been before. So nothing much to add beyond that. Any questions here?
Any questions?
I have a question. Will it say bank, Citizens Bank, or just Citizens?
They'll say just Citizens.
Any other questions?
It's fewer letters.
Please.
Thank you.
Thank you, Mr. Becker. The next witness I would like to call is Pierre Galinas. He is from Philadelphia Sign Company, and he will give you the details with regard to the signage itself.
Do you swear affirm testimony you're about to give in tonight's proceeding, please truth, whole truth, and nothing but the truth?
I do.
Your name for the record, spelling it.
It's Pierre, Pierre. It's Galinas, Gelinas.
And Mr. Galinas, if you would, for the board, go into the detail of the sign as to the size, the lettering, because we're here for variances, the location, graphic area, and how it relates to the building.
Very good. So we are looking for a 4 foot 3.5 inch overall height by 25 foot overall width sign to replace the existing Investors Bank sign that was removed as part of the conversion scope. The new sign is similar in height. The previous sign was 4 foot 6 inches. We're asking for 4 foot 3.5 inches high. And the previous sign extended 33 feet wide. We're asking for a 25 foot overall width now due to the decrease in the amount of letters. Sign construction is similar to what was existing. It's fabricated channel letters powered by LEDs, 6500K illumination color. The face of the new letters is proposed to be the Citizens Green branded color. Will illuminate green at night. The previous sign had the Investors branded logo, which consisted of 2 green colors, and it had a day-night black letter scheme, which would appear black during the day and white at night. Proposed height of the letters is 77 feet above ground. That will provide adequate visibility from possibly the street, so people can identify the building. There's no current other branding on the building that would identify it as a citizen's office. Letters are in the same position as the previous Investors Bank letters. And I believe that sums it up. Any questions?
Previous sign, the investor sign, the same illumination.
Yes, same illumination, just different color.
Same lumens?
I believe so, yes.
Any other differences between the two signs? Like the size of the heights or whatever, the size a little small.
Same generic construction. Nothing too different. Just different logo.
Good question. Are there any apartments nearby that this could shine, that people can see while they're living in their apartments?
Well, the new apartment buildings that went up are past the Short Hills Mall, which I believe is a distance away from that side. And this sign is facing JFK Parkway. I'm not good with east, west, north, south, but it's facing the mall. I'm familiar with the mall. And the apartments are to the, if you're looking at the mall in Bloomingdale's and Macy's, I know the stores, it's to the left. So I don't believe, I'm not an expert, but I don't believe this could possibly interfere with anybody in the apartments.
Yeah, and to add to that, I did visit the location today ahead of the meeting, and I did notice that there was a lot of tree cover in between that building and the office building.
To the best of your knowledge, there's no apartments that this could affect.
No.
Thank you.
I would suspect this would be on 24/7, especially during the nights. Is that, I mean, just like the investor sign was previously, there's no change on that?
There wouldn't be any change. The power is existing. We'd pull it from the old sign. That hadn't been removed, just the letters and the secondary supplies.
Dusk to dawn?
Yes.
One more question. Do the lights point up or down?
They're internal lights, so they just shine through the face.
Which is what investors do.
Okay.
Any other questions?
This is the only sign on the building?
This is the only sign on the building.
Anything else from the board? Any questions from the audience? Any comments from the audience? Then I'll close the public portion of the meeting. Board members? Any thoughts?
I mean, for me, it seems fairly simple, right, that like one company has taken over another and we just need to replace their sign, replacing it with basically what was there and your submission.
And it was previously approved, so.
Yeah, we're not increasing the brightness of it. The sign is actually striking, so I have no issue with it.
My only comment is that it doesn't say bank, whereas Investors Bank said bank, and I don't know how confusing it might be for people to see the word citizens on the building, would they think this is town hall? Or something if they really have no idea where anything is in Milburn Township.
Am I allowed to speak to that or not?
I close public portion.
Okay.
Yeah, but anyway, that's
the
really a
branding,
comment,
right?
it's not,
This is-
it's actually,
So,
yeah, it's not, yeah, I mean, it's, they can put what they want, but I say
Right.
I would feel better if it said the word bank, but.
Okay.
Just a comment.
and would like someone like to make a motion?
I would like to make a motion to approve the application.
A second, please.
I can second.
Sean, do it.
Yes.
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 Yes. Good luck with your new sign.
Thank you very much.
Lastly, this evening, we have another sign
I
application.
know. It's
392723, Charles Schwab, 350 Milburn Avenue.
Thank you, Chairman Richard Skolnick, on behalf of the applicant, Charles Schwab and Company. I'm going to have three quick witnesses. First, David Mandelbaum from the ownership group, just to talk about the rehabilitation of the movie theater. Then we're going to have Perry Brunner, he's an in-house architect, just to go over the details. And I have Mr. Keller talking about the variances, so I'm not going to talk
I'm
about
going to hold you a quick, not Mr. Keller. Okay. The other two,
what's the penalty on that. Well, he'll try. He'll try.
okay,
With that, can I call Mr. Mandelbaum?
please do.
Okay, you're all familiar with the building. We're talking about the movie theater, so we can discuss that. Mr. Mandelbaum here with the ownership group.
Swear from testimony about to give you. Tonight, the truth, the whole truth, and the truth.
Yes,
Your name for the record.
David Mantelbaum.
Okay, you're affiliated with the ownership group, sir.
Correct.
Can you just talk a little bit about the rehabilitation, what you've tried to do with the movie theater?
Sure. So, David Mandelbaum here. I have, as everyone's doing, try to keep this quick tonight. So, in support of this application and to provide some design context for our tenant, Charles Schwab. So, we are so excited about this project. This was a great adaptive reuse project that kept Charles Schwab in our downtown. First thing, when we looked at this project, we looked deeply at the history of the site as we wanted to make sure that our design on the front facade and the canopy comports with the historical nature of the site. And in doing so, on the canopy specifically, we've reduced the canopy from about 350 square feet down to 90 square feet, which in our opinion provides a little bit more of a sophisticated, cleaner look. And to our knowledge, there's always been a large marquee with lettering above the canopy. We wanted to stay true to that historic design element, and therefore we always envisioned our tenant signage to be above the canopy. We also moved the entrance, or actually we centered the entrance and moved the staircase to the right, which was similar to the old historic imagery that you can see there. And we removed the pillars that were holding up the old canopy, so providing an easier pedestrian walkway. So all in all, these adaptive reuse projects are not always the easiest. This one was no different, but we couldn't be more proud with the end product, and we're excited to welcome Charles Schwab to their second home within our beautiful downtown.
Thank you. Any questions for Mr. Mandelbaum?
The entire building's going to be Charles Schwab.
On the first floor. On the second floor, we have some.
Second floor, other tenants.
Say that again. So the first floor is Charles Schwab and the second floor is someone else?
Yeah, we just have some office tenants, some existing
Okay.
tenants over there.
Thank you.
Please proceed.
Okay, we'll call Perry Brunner. He's give me his title, he's with Schwab. We can have him sworn, please.
Swear from testimony about to give tonight's proceeding, be the truth, whole truth, and the truth.
Yes.
Your name for your record.
Uh,
Perry Bronner, Perry, Brauner, and I'm the senior design manager with Charles Schwab.
And you're actually an architect licensed in New York?
That's correct.
Okay, Chairman, I'm not submitting him as an expert witness, but, because he's just going to talk about physically what we're proposing, but you do have that architecture background, correct, sir?
I do, correct.
Okay, you were involved in the development of the plans with the sign company.
Absolutely, yeah, we worked closely with the ownership group as well as our sign company to come up with a sign proposal in front of you today.
Okay, you happen to live in Livingston, so you get the honor of testifying.
I do,
in this application.
I do, yes.
Okay, can you tell us what is in front of the board tonight in terms of the proposal and why Schwab is looking for this package?
Sure. So thank you for having us tonight. I'll try to keep this brief as we value your time. My name is Perry Bronner. I'm a senior design manager with Charles Schwab. I am a registered architect in New York. My job is to coordinate the overall design of the space aesthetically, from the exterior signage to the interior finishes, lighting, furniture, all of that. Like Rich said, I grew up and still live about 5 minutes from here in Livingston. I've seen many movies at the old movie theater. Love Milburn Deli, so I'm proud to play a small part in the restoration of this old building, along with the owners. Charles Schwab has been a part of the Milburn community since 1980, and we're making a strong commitment to stay in downtown Milburn, building a branch that's about 2 times larger than our current branch. We're really excited to kind of be more of a feature of downtown, moving a couple buildings down. Our signage is manufactured by Priority Signs. They're a national vendor. They do very high-end design. Priority does work for a lot of major retailers around the country. It's not your strip mall signage. It's a high-end sign. So I'm going to put up our first sign labeled as S1 in the package.
Okay, this is exactly what was in the package?
Yes.
Okay.
So as we've talked about historically, this building has had a marquee sign, and what we're trying to do is maintain that. We've got a canopy here, and we're looking to put a sign on top of that canopy. The current branch sign at Schoolhouse Plaza, a couple buildings down, is a very similar design. It's a channel letter set on a raceway. We just happen to have a brick facade that it's attached to. So we're looking to do a very similar sign, but on top of the canopy here at our new location. We feel like the marquee above our main entry creates a perfect opportunity for the sign architecturally, and it's in line with a movie theater marquee that's been existing for years. The sign that we're proposing is much smaller, and we feel more aesthetically pleasing than the previous movie theater sign. Our top priority typically for exterior signage is our blue logo sign, and we'll get to that for the next sign we're talking about. That's our main branding element, but we felt that it was important to forego that to respect the architecture of the new building here in downtown. We are proposing our inline Charles Schwab script letters, which we feel fits nicely above the marquee. We are also using a perforated day-night film, so it'll appear black during the day, but when the lights are on in the sign, it'll look white at night, allowing it to be easily seen.
Just keep going and then we'll get to board's questions.
All right.
Okay, we'll just call out the sheet here.
Yep, so moving on to sign at S5, which
This is
is
the back of the building.
just on the rear of the building, correct. So like I mentioned, our main priority is our blue logo sign. It's a trademark sign. It's square. I'm not allowed to do anything with the orientation of that sign. It's square. That's what we can do with it. I've been shot down many times from the branding department to change that. But our main priority with this sign is to get our main branding element on the exterior of the building to help signify this as the Charles Schwab building. There's a lot of visibility to the rear of the building from the adjacent municipal parking lot off of Taylor Street, so it would help residents and clients find the building a lot easier. Without the sign, we feel like the rear of the building will be a large blank white brick facade with no real distinguishing features, making the building difficult to find from the rear. Architecturally, we feel as though the proposed sign is appropriate height and size based on the immense square footage of that rear facade. And the letter height on the proposed sign is slightly larger than 12 inches. So it's not a large letter height. And we feel like this building is uniquely designed and situated, and we feel like our branding is appropriate for the size of the facade.
So quick question for you.
Yes, sir.
This classy sign in the front, and we got that in the back. How many buildings in town have a illuminated sign 30 feet up in the air?
I don't know, but you just approved them.
In the downtown?
Oh, downtown, sorry.
The
Yeah, I said in town, sorry.
That's 70
No,
feet,
okay.
that's over there.
Yeah.
No, 30 feet of downtown illuminated.
I don't have that information.
Yeah, it's 0. Why not put a sign that looks like the front on the back?
Like I mentioned, this is our main branding logo. It's our beacon, and it's our priority to get that on the exterior of our buildings whenever possible.
How about lower? How about not 30 feet up in the air?
Aesthetically, if you look at the shape of the building with the gable, it feels like it fits there. It'd also be more visible to those on in the rear parking lots.
How late are we open tonight?
Varies from branch to branch. I would say 5:30, 6. Sometimes we have seminars at night.
Does it need to be illuminated?
Does it need to be illuminated?
Right.
Our preference is for it to be illuminated.
You don't have customers past 5:30. Does it need to be illuminated?
We like to mark our location as the Charles Schwab building, so it would be nice to be visible at night, even if it's not open at the time.
Fine. Any other questions?
Same questions too that I did to the previous applicant. Do you know if there's apartment buildings that this light could possibly affect while people are sleeping at night or just living their lives?
There are office buildings directly behind us. I don't know that there's a lot of residential facing.
Mr. Keller can address that issue.
All right, yeah, because this is the back of the building, and just to be, for clarity's sake, we are not discussing this fancy sign that's in the front. We're discussing the large blue sign that's in the back, correct?
There is a
That's,
variance.
that's the one that the variance applies to.
There's separate.
They're both required.
Yeah, they both require.
So
They
the
both
one
require
in the
variances.
front and the one in the back, so this, okay.
Yes.
Thank you for clarifying that. So it'll be illuminated all night, and you're not sure if there's people that are living nearby.
Mr. Keller can talk about that.
Okay, and are the lights shining up or down?
Similar to the previous applicant, it's an internally illuminated sign, so they're just shining straight.
They're shining all over.
And the one in the front's illuminated from underneath, correct?
The one in the front is also illuminated inside each letter,
Right.
so it's kind of going straight.
That's what the building looks like in the back?
Currently, it will be painted white.
And the lights are gonna be behind it.
It'll be inside the sign,
Okay,
facing.
so it's not like
facing
a-
So on S1, in the picture of what it's gonna look like, there is a Charles Schwab, a blue Charles Schwab square. I assume that's just a temporary sign.
That's interior.
Is that actually what people are gonna see in the future when they walk by? Or
That will be visible. Yeah, that's
in
our
addition
intention.
to the
to-
larger sign that you want on the end?
Correct.
So it's 2 blue signs, one in the front, one in the back, and then the letters on the top of the canopy.
Correct.
And how tall are the letters, sorry, in the front?
In the front, sorry, trying to memorize. So we have a unique challenge with our logo in that the H and the L are always a lot higher than the rest of the letters. So the total height of the letters is, here we have the dimension of including the raceway, but the letters themselves are about 2'2" from the bottom of the C to the top of the H, which is the tallest letter. But the Schwab section of the letters, which is the majority of the letters, those are only 1'4" tall.
Okay, thank you. They look a lot bigger in this picture. I don't know if this is drawn scale.
It should be, but our sign vendors' renderings aren't always 100% perfect. But it will be built to the dimensions that you see on the.
Okay, so so the letter B is less than 2 feet tall?
The letter B is 1'4".
The blade sign, how far is that off the ground?
I don't have that. Do you have that? I'm sorry.
Eight-ish.
Yeah, I mean, it would. It would definitely be at least 8 feet off of the ground. I don't have it noted here.
Okay.
It would comply with,
Blades,
Yeah.
blades on your building?
yes.
Yeah, that can apply.
I just want to point out, it's not so much the height of the letters which are in violation. We don't have a standard that measures this sign, so technically, I have nothing to gauge it on. We allow wall graphics and ground graphics. This is neither, so that's why it's here.
You allow, say that,
Wall graphics and ground graphics. This is neither.
So to Craig's point before, there's nothing in downtown that's illuminated because there are wall graphics or.
I think he's referring.
No, I'm referring to the sign
He's
rear.
referring,
Oh, this- yeah.
No, I'm referring to the height of the sign in the rear.
But I,
The front, no, I mean, there's a lot of signs that are illuminated down there.
yeah,
are there other signs that are illuminated at night on the front?
Oh, yeah, most.
There are, okay.
It's just, yeah. So there's two different things here. You have the front
Yeah,
issue
yeah.
and the rear.
Mhm, yeah.
Please continue.
Are both signs the same brightness, the front and the back?
yes.
And is it a standard brightness? Like how did you decide how bright it's going to be?
It is. So I'm not a sign expert myself. I deal with a lot of the design of signage, but yes, I mean, it's our standard illumination that we do around the country.
Any other questions? Let it be known that there's no one in the audience to ask questions.
Yeah.
Associated with this case.
Everyone else is in bed.
Please continue, Mr. Scully.
Okay. 1 second. Okay, we'll call Mr. Geller. Have him sworn, please.
You swear affirm testimony about the given tonight's proceeding be the truth, whole truth, and nothing but the truth?
Yes, I do.
Okay, Chairman, I assume you'll accept Mr. Keller's professional qualifications so long as his license hasn't been revoked recently.
Yeah, I think we've seen him before.
Okay, has your license been revoked recently?
I was on my email before, no, still good standing with the state of New Jersey.
You have some thoughts on this application?
Yes, I do.
In terms of the relevant criteria?
So since it was referred to, we didn't enter it as an exhibit, what the ownership was referring to before was facade elevation, evolution photo board A1 dated 6/5/2023, and it showed 3 photographs capturing 3 eras of the building. The first, the building was built in, or became a movie theater in the 20s. The photo up there is from the Historic Society from the 1940s. You can tell it's a 1940 Oldsmobile Cruiser there. And you can see the building, the entrance to the movie theater and the large marquee were centered on the building. And the marquee was rather large with signage facing on the top of it. In 1998, it was divided in half for 2 movie theaters, but basically the same facade. And then in 2013, they actually infilled the central area to make an office and box office. They shifted the entrance over to the left asymmetrically, and they put up the 44 by 8 foot canopy supported by 4 columns with a 40 foot by 4 foot sign that at the time said Milburn Cinema 4 on it. And then in 2013, it became Bowtie Cinemas when Clearview bought it, and they maintained the same size. And there's that 40 by 4 foot, and there was an 8 foot by 4 foot signs on either end. So there was historically in the front, let me just verify, it was actually 44 foot long by 8 foot, and the 2 side pieces. So there was a total of 184 square feet of signage on the building through when the theater closed in 2021, and you add another roughly 15 to 16 square feet for the Bedazzled, the other tenant. So you're up about 200 square feet in total. As indicated, we're here because we are proposing, first of all, a sign in the front that's not a permitted sign. We don't permit canopy signs in the B4 zone. We expect them either to be wall-mounted graphics, and there are some metrics for that, or we expect them to be freestanding signs, which are not permitted actually in the section, or awning signs. In this particular case, sort of honoring the historical relevance of the movie theater,
after the owners really significantly sized down the front canopy to a more appropriate size, reestablished the center axis as the primary entrance, painted the building with much more attractive fenestration. They came back with that same sort of central awning or marquee, not awning, but a marquee or cantilever, also tied back into the building with metal struts, the same way the original one was, and that becomes the entrance. And it felt like the most appropriate place to put any signage on that was a sign that is almost identical to the one they have across the street at Schoolhouse Plaza, and that would just float right on the top of the existing marquee or canopy. And there is about a 4-inch channel that actually almost makes it look like it's part of the canopy. And above that sit the letters. They do go to about 2 foot 2 inches in total. The total square footage of the letters is actually 9 square feet. So it's very little. And when we talk about it being internally illuminated, it's an exterior film. It's black. So during the day you see black, and there's very little pinholes in it. So at night when the lighting comes on, you don't see a direct source, but it just glows as a soft white. So it's not like a light that will shine in anyone's eyes. It just allows for the Charles Schwab to glow, very similar to what's right across the street right now, and almost the same size as well. So we felt really that was the aesthetically appropriate place for it, rather than building mounted facade. I would point out that if you take the signable area, which is the area of the first floor, excluding the glass and the doors, that we're well under 20%. In fact, if you add up all the signage on the building, including the 64 square feet in the back, all that square footage added together is still less than 20% of the signable area of the front facade. So in terms of overall signage, and I'll talk a little more about the scale in the back in a second, but overall signage, it's actually undersigned or consistent with the total amount of signage you'd expect to see on a front-facing building, and that covers both our front and back. So we need a variance, not necessarily for the height of the graphics, but we need it just for the fact that we have a canopy sign, which is not a permitted type of sign. It wasn't really anticipated. The rear of the building, and I'll go to an exhibit. This would be my A2. Also with today's date. This is 3 photographs and an aerial photograph.
We're going to call that photo board 2 for the record.
It's called photo board number 2. Photos 1, 2, and 3 were taken by Casey and Keller over the weekend, 6/4/2023. The top 3 photos show 3 vistas from either the public streets or the parking lot over to the back of this building. Obviously, the back technically is a 1-story building. The front has the mezzanine with the 2nd floor offices. The entire back is actually a 1-story building. But if we look at photograph number 1, this is as you're heading north on Milburn Avenue, as you're waiting for the light just into 75 Main Street before you get to Rock and Joe's. There's about a vista. If you move 20 feet to the right, you can't see the back of the building. You move 20 feet to the left, you can't see the back of the building. You can see we didn't superimpose it and make it white because we're not Photoshop people, but I did superimpose the size of the sign at 8 foot 8 foot by 8 foot diameter blue background, which on that has a relatively small floating letters that is the script and the non-script Charles Schwab, which is their standardized logo throughout the country. It's their logo. Photograph number 2 is when you're just coming into the parking lot 4 off of Taylor Street. You can see you get a framed view. There's not much view of the lower part of the building, but you do see that frame section up in the it sits squared in the pediment, as indicated by the previous witness. It's really seen as sort of an architectural embellishment and what's going to be a large white facade, and they felt it was best located up in that area for balance between the windows and the facade above. And when you look at it in terms of its location, certainly as you get that first frame view, it actually is visible above the trees, above the cars, etc. These photographs, by the way, are keyed into the diagram below, the aerial photograph. This represents the site on October 6th of 2022. It's a scale of 1 inch, it's 30 feet. And you can see photograph number one. Number 1 is on Main Street heading north.
October 6th?
October 6th,
Okay.
2022. So you can see that we're looking, you're getting that slot. If you move 20 feet to the left on the street, it's blocked by 75 Main Street. Move further, you're either blocked by the trees or you're blocked by the building at 75 where Rock and Joe's is, and those tenants there. So you get that one little vista in there, which means if I'm coming into town for the first time, waiting for the light, I see, oh, there's the Charles Schwab building. I'm going to navigate through the one-way streets and find my way over to that building. So same as you're coming in, if they refer you to the public lot that's accessed either off of Milburn Avenue or from Taylor, as you come in, you get that framed view. If you look to the right, you'll catch just a view between the trees. And then once you're actually in the center of the parking lot, so you're in the center of the parking lot and you're either walking towards Milburn Avenue, or you can navigate through the backyards and up the two sidewalks. That's where you get your view. And it is a little bit oblique, but that's where you get your view of the sign again. And we did feel architecturally this was it was really more of an architectural embellishment up in that section. We really did not want to put Charles Schwab either down lower because it has better visibility, and it really has no impact on the surrounding residents. There are no apartments in the surrounding buildings immediately adjacent to us. You start some single family, it was a single family and some multifamilies that are more than a football field away, but they're also at quite an oblique angle. So as you look out those windows, you're not going to see anything. And then, again, the way that these pinpoint screening work, you're just certainly not going to see any light source. You're going to see that glow of the blue sign floating above. And yes, it is up high, but we felt that it really becomes, as we indicated, an architectural embellishment on the back of this one-story facade. Unfortunately, because the facade is right against the back property line, we were not able to put any windows up there because you get too much heat gain. We couldn't get any blockage of the sun. We couldn't do canopies. So there are the windows down low, and you have a very large white area, which we thought was most appropriate. Now, can it be brought lower? Probably could be brought midpoint. Once it gets too much lower, it's going to stop having any efficacy in terms of wayfinding for people to the site. So the team felt that that was the most appropriate point. It is 8 by 8, but the actual letters are much smaller that they floated in that. It really becomes more of a logo. You ever seen some of the Starbucks actually just have the siren? They don't have the words anymore because people see the siren, they know it. So here it's like you see the blue square. If you're coming to the downtown, you know this is where you're going. And the variance really necessary for that is wall graphic height in the B2 and the B4 zone. The maximum allowed is 8 feet. And you're not allowed to have graphics above the first floor. Technically, it's not above the first floor because this is a one-story building, but it is what you perceive of being as above it, so we noticed for it. And then there's also another section, 609, 10 G1, and that is where street graphics may be displayed on the side or rear of a building adjacent to an off-street parking area if the off-street parking area is 40 feet or more in width. Paradoxically, we are adjacent to the parking lot that's 40 feet in width and another 40 feet. So we've got about 70 feet by 50 feet of parking. It's just neither of those are on our property, which is not what the ordinance says, but I think the intent was would be on your own property or be contiguous to a public lot. The public lot is actually outlined in green here. This is Township Lot 14. This is where people could be coming to it, either coming off of Milburn Avenue, coming down, or coming up Taylor Street Park. And again, this is where you'll get these two quite framed views of the sign, as you either then come up either the two sidewalks or you come out to Milburn Avenue and come along into the front entry. So that's the variance relief required. We think this can be approved under C2 of the municipal land use law, C2 being the flexible C variance. Again, this is one that does not require a hardship. This is one where we believe that the proposal with the deviations represents a better planning alternative to one that will be conforming. And to demonstrate that positive criteria, we need to show that the purposes of the Municipal Land Use Act are advanced from the deviation of the zoning, and the benefits would substantially outweigh any detriment. With regard to the sections that are advanced under 4055 D2 is Section A, which is general welfare. General welfare on the signage and combined is advanced in that we have a tenant that took a leap of faith They needed a bigger space. They needed something that wasn't stuck under a canopy, 25 feet back from the street. They wanted higher visibility. They needed more space. They wanted to make a commitment staying in the town. They wanted to work with the owner and doing a really high-end renovation of the facade, as was demonstrated on the bottom photo. Of course, signage is important to that. Their signage on their existing building sits way back from the street. They are financial services that are looking to increase their amount of one-on-one services with both members of the community over in Short Hills and the surrounding areas. It's critical that people have wayfinding, and it's critical that that they establish themselves. Having a nationally recognized business such as this take over one of the larger buildings in the downtown allowed for this building to not stay on the market, not grow fallow, not stay vacant, and allowed for a prime piece of real estate to be occupied in a very high-end manner. So that certainly advances the general welfare of the public. The last thing we need is another Futter building or another large building in the downtown that remains vacant for years and years. Office space is not at a premium. So I think it was important for us to capture this tenant and work with them on signage to get them to make a commitment to our township. And certainly we think that aesthetics are advanced on both the front and the back. Certainly in the front, I think the most appropriate location is to honor the history and aesthetics of this marquee type sign with the signage above it. It's very restrained and only 9 square feet of letters that sit above it. I think it's appropriate in terms of its size and scale. I would point out that rear signage, it is important for wayfinding, both as people are coming into the town. It is actually, we think it's an architectural embellishment. So it enhances safety in terms of wayfinding, so you know where it is and you can navigate to where you park and you can find the building. It establishes the honorific notion of this downtown tenant establishing this as their building, which will hopefully stay their building for the next 100 years. We won't lose another tenant. The rear sign is less than 100 feet from that public lot 4. We recognize that it is a little different and it's large and it's square, but it is the one area where Schwab really felt like they were willing to give up the front area and not go with their recognized logo, but they were really hoping to get it on the back. We can certainly talk about lighting and location, but we really did think it was the most appropriate in terms of the architectural embellishment. And again, once that's white, I think that'll really pop and be quite nice. So I think I think with regard to the negative criteria, we need to demonstrate that there's no negative impact to the neighborhood and there's no substantial detriment to the public good. And finally, there's no substantial detriment to the intent and purpose of the zone plan and zoning ordinance. The signage is elegant. It's appropriately scaled to the different facades, both front and back. There is significantly less signage on the building than it replaces. If you add up all the square footage in the front and the back, it is 76 square feet of total square footage, down from over roughly 200 square feet previously. I would point out that if you look at just the back of the building, just the area where you look as the first floor, that square footage represents only about 6% of that area down there, the non-windowed area. If you look at just the area below the pediment, that represents about 3% of the total area. And if you were to add the back 64 square feet plus all the signage in the front over that smaller front area, you'd still be less than 20%, which is one of the metrics which we use for judging when the signage gets too much. So the signage on the whole building is less than what we would normally permit on the front of the building. I think that in terms of any of the negatives are kind of mitigated by the fact that this signage is actually, especially the back, is blocked from 75 Main Street and has very framed vistas from anywhere along Taylor. Any of the residences are more than 300 feet away, and they would have to look quite obliquely at it. I think that there really is no negative impact associated with it. And there's no substantial impairment to the intent and purpose of the zone plan and zoning ordinance. I think that rear signage is actually consistent with the intent of the ordinance. It says if you have a back that's on a parking lot, it's appropriate. Well, They're not directly our parking lots. 75 Main Street is used by Moonshine as well as their own tenants, but we're only 100 feet away from that public lot where we do expect people will park. With regard to the master plan objectives, certainly we don't cut across any of those purposes or objectives. We think this tenant will maintain and enhance the economic vitality of the downtown business district. Our master plan objective is to promote opportunities for high quality commercial activity in the business district and to leverage opportunities for new commercial development or redevelopment of existing properties where appropriate. I think the signage is kind of key for what Charles Schwab is looking to do for our downtown. We certainly think that it will strengthen the existing business center in our downtown core. We think the signage is elegant and attractive. I certainly take any questions or we'd listen to any suggestions.
Just one last thing, just in terms of overall reasonableness of the sign package, you have a comment on that from a planning standpoint, what's put together here, taken as a whole?
Well, I think you do take it as a whole. If we take it apart and you say, well, we've got a large blue square at the back, which is really an architectural embellishment, and on that, there's 1/3 of that, or 1/2 of that is occupied by some white lettering. I think when you take the whole sign package together, as I indicated, you take all of the square footage, back and front, it's still less than what we were permitted on the front of this building if we did wall graphics. I could put an entire 77 square feet on the building in the front of this building, and we're not doing that. We're being much more elegant, where Charles Schwab has worked with the owner to not go with their iconic or their logo, Charles Schwab, in the front. They've asked for it in the back. So I think on whole, I don't see any negative to the community. Maybe we don't have a lot of 64 square foot blue internally illuminated boards with lettering on top of it in the downtown. We also don't have very many large theater buildings in the downtown that are much different scale in the back than any other building we have in the downtown. So I think for the fact that it's got such frame views, there's really no negative. I think that the signage is appropriate and can be approved by this board under C2.
And thank you for being so brief, Mr. Keller.
So quick question for you.
Yep.
How difficult are people wayfinding the current location?
Say again?
The current location?
Yeah.
Is there a wayfinding issue there?
Yeah, there is. Yeah, because we actually did the variance for Schwab when they moved in, as well as the other financial services company next to them. And the signage has always been a problem because it's set, that mass of that building is not set either level on the street, and it's also set back considerably from the sidewalk. And then with under that, you've got that Charles Schwab that floats on the building, and then you've got sort of a big overhang. It's an 8-foot overhang, and somewhere in there's a door, but it's often dark in there. So you've got a sign that looks orphaned on the outside of that building. It doesn't give you a whole lot of direction on how to get there. There is no signage on the back.
Why not the 30-foot architectural embellishments on the back of them? Why don't you apply for that? Schoolhouse Plaza. I mean,
We may do that sometime. No, look, it's a different owner. It's a different building. Certainly,
level of investment into the community.
I also think that that building, unfortunately, is on display for all of the 1 and 2 and 3 family homes that are on Taylor, whereas this is not. So if you were to
if
put,
you can't see it, why do it?
well, because it is framed occasionally, but it does give you a glimpse. And really, the place where you will see it, even though it's somewhat oblique, is when you're in the heart of that parking lot. So when you're in the heart of parking lot 4 is when you will still see. So from this range, you'll still see the back of that building. We thought it was actually, the applicant thought it was more architecturally significant to put that embellishment at that portion rather than putting a sign along the bottom facing into the parking lot. Actually, that would get blocked a little more by some of these trees. It would get high visibility in here, but it was also less of an architectural embellishment, less of an opportunity to break down the mass of that big facade. So you couldn't
And
do
a
it
sign
like
like you put in the front, which I would agree is elegant, on the back.
I think it's going to get lost. I think when you keep it down low, it's gonna get lost. And it does.
There's no door there though. You can't enter the building from that side.
There are doors, but they're only egress. You're correct. But there are two sidewalks that go up. There are 2 sidewalks that come up on either side up into the front of the building. So if I'm here, I can certainly come across There's an entrance up onto the walkway on the west side of the building. So if I come right through this lot, which people often do come through there, I come right up the sidewalk and I come into the building. There's an egress door on both sides, but there's no other egress.
So take that grouping of buildings there. We got Silversteins, we got all this stuff. So how many of them have architectural embellishments 30 feet up in the air?
How many of them are 40 feet with no windows? So there are none. You're correct. But all those other ones are articulated with windows throughout. So this building is different. We can't get any more windows up top. If we had more depth, we had 5 feet further, we could put some canopies on, get some shading. As it is now, there's a fair amount of solar gain through these windows now because they face south. So we can't get any windows up here to break that facade up. So we've got this 46-foot facade, which is going to be a very large white mass. And so we felt it was an opportunity to articulate that. Is it necessary? No. But it's really it's an opportunity for this applicant to get at least one spot where they felt it was appropriate to get their signature signage.
Any other questions from the board? Go ahead.
Do you know if the movie theater light was on all night?
The movie theater light.
It was, like the marquee.
In the front, you're talking?
Front, anywhere. The front, we'll start with the front. Do you know if the front was on all night?
My I can't speak honestly. My recollection was that it was, but I can't. I was not there at 3 in the morning, so but I know it was on after movies were letting out. It was still on.
My recollection is it was off at night.
It was off.
Yeah, right. So the movie theater lights were off at night, but these,
I wasn't
yeah,
there.
but these lights will be on all night.
Again, but this is very different in its aesthetic than this with lights behind it, where this thing glows much brighter. Whereas the pinpoint lettering, and I can let our sign Schwab representative, a little more familiar with signs, talk about it. It does. Well, we could all go to the window. We can look at it, but it's. I think that's, besides being much smaller, this is much brighter.
But it wasn't on all night. Okay. And do you know if there are apartments across the street? Like I think it's La Strada. I'm trying to think of the geography. Like there are apartments across the street from the movie theater.
Yes, there are. Not. Yes, there are. Trying to think of where the movie theater. Let me look at the area.
Chairman, my clients indicate we could put the rear sign on a timer if that's a concern, to try to address maybe 11 o'clock at night.
In the front, where the apartments are?
We're talking about the back.
The back. And the front, there are apartments that are directly across the street from them.
Well, the first overlapping much of the building is the building that Carrie Heller owns where the Starbucks is, and that does not have apartments. It's when you get next to that. So probably starting at about midpoint of our building is where you start getting some apartments. But certainly this will be much less bright than the movie theater was. And this is our downtown.
But the movie theater was off at night.
Yeah, but this is our downtown. This is where you kind of expect to have lights at night and apartments that coexist.
The current Charles Schwab sign right now, is that across from apartments? The current-
I'd have to, unfortunately, I cut this off, so like I said, I think that the apartments probably start about midway to the right side of our building. I don't remember exactly how long Carrie Heller's building is through here, so nobody wants to adjourn, I could run down there and check. Want to take a 5-minute break? I think most of what's across the street is going to be Carrie Heller's building, which has no apartments. The apartments start after that, and they're second and third floor apartments.
And the current sign is on all night. Is that right?
The current sign, what they're proposing would be on, their proposal is it would be on.
Not the
current
current
sign.
Oh, the current?
Just dawn or?
The current one.
Well, there's no current sign.
No, the current Schwab sign.
Oh, the current Schwab. I think that's on all.
Yeah. Is there an ordinance that deals with the hours of operation of signage?
No, it's dusted on.
We would certainly comply with whatever municipal requirements there are.
Any other questions from the board?
Do you have what's the property offset for the rear of the building? Is that an encroachment, that sign?
No.
Okay. What is that distance?
We've got my recollection.
You were concerned about not being able to
Yeah,
put canopies up.
we had about a foot there. Which I was gonna get a
A foot?
canopy,
It's only 5.5 inches of your sign step.
Yeah, we have about a foot in the back to the property. We prepared the survey, but I didn't bring it with me.
Any other questions?
I just want to be clear on this. Are there any other businesses in town that have a similar signage like this that you're requesting?
I'm not sure what the comparison.
Like of that size,
metric is.
illuminated on at night?
You have much bigger signage all across the front of the CVS building. I don't know what hours they are, whether-
CVS,
when those go off.
down
but
in Milburn?
Much larger signage, and those are directly
Taylor?
across from.
Yeah.
No, the ones on the CVS.
Vauxhall?
So,
Yeah.
Oh, no,
One
way
town
down,
building,
but Milburn, okay.
The Orange Taylor building,
Yeah.
Yeah, the old orange one.
On some, we're not looking for relief on the size. The testimony was pretty clear. We're actually much smaller, and that's part of our argument, much smaller than what's permitted. And so we're asking the board to take everything into consideration. There's some case law on the C2 variance. They look at the entire proposal. So
Is your illumination going to be in compliance with the ordinance?
Yeah,
certainly,
Thank you.
certainly. But
But the
we're
height-
asking for consideration of the entire package. Obviously, a commitment from a significant company to take a big block of space, to rehab the building in an appropriate manner. I don't think there's any issue with the front and the appropriateness and the classiness of the front. But if you take it overall, Rich talked about our overall size is smaller. So we have a large municipal parking lot. We think there's good balance here, taken overall. Schwab would certainly like it. They want to have their branding efforts, just like Citizen. But there's also the building where I work at 75 Main blocking it. So it's not slapping you in the face from at all times. And we have an agreement to put it on a timer to get an appropriate balance, to balance the needs of the business community with the community's interest in reasonable regulation. So if we take the whole thing together, we think we have an appropriate package. We appreciate your time, longer than expected. I can't control Mr. Keller. He won't give me his notes.
What would you have me leave
He
out?
won't give me his notes before the meeting. It's a problem, but we have to work with him.
Absolutely agree. Let also be shown that there is no one left in the audience for comment.
We tired everybody else.
So with that, unless there's any other questions for the professionals, I will close the public portion of the meeting. So, board members, what are your thoughts?
I think the front is really, really nice. I love the attention to the historical details. And you know, how you're not only preserving, but going back to closer to what the original was. So I'm really, really happy to see that. I wish I could say the same for the back. I don't necessarily, feel that way. I don't know that it's that egregious that I wouldn't vote for it. I actually think it would look better if it was a little lower and, just a little more centered between the first ridge line and then the top of it. But, I'd be curious to see what my vote.
I was thinking
I get it.
Hang on 1 second, let's go through them.
Yeah, I'm just saying, like, to me, it looks like it needs to be like one space lower. That's just me, so.
Dash, you were saying?
Yeah, that's literally like our brains were thinking the same exact thing. The blue sign, I think, should be equidistant between the ridge above the windows and the pinnacle, like in the middle. I don't know, it looks kind of like a stamp on a building, But, and otherwise, and the front signage, I echo, is really nice.
Yeah, I would agree with the same thing. I think the front nails it. It just has a certain elegance to the downtown. I like that blade effect. I think it's a lot more modern. If we just put, these orange theory as an example, I just don't think that is, critical for today. The rear is something I would see on Route 22. I just don't think it's in keeping with the downtown. We don't have signs up at that level, illuminated signs that high. It's not in keeping with that group of buildings in that general area. And I'm pretty sure people will find the Charles Schwab building in daytime hours because that won't be illuminated during the day, and being that this building isn't occupied after 5:30 or thereabouts, people are coming to say, I'll drive past it at night and maybe I'll find it in the day. So at the end of the day, I would love to support the application, but with that in the current configuration it is, I just don't think it's in keeping with the downtown. So, to break this application apart, I'd support the front, wouldn't support the back. And even lowering it, I still think it's not in keeping with, I'd love to see the same elegance in the front and the back. So I feel like we fall apart here, where we have this great sign that was imaginative and creative and a real asset to the downtown. Then we get to the back and it's like, oh, there it is, like a big square box that's lit up. So, 30 feet off the ground, which there's no other signs like that in town. I mean, come on. So I would not be supportive.
Look, from my standpoint, I mean, this is $100 billion corporation accommodating to work with us, putting up the office, office location which could have been vacant. And I think I appreciate that. That's actually a very good commercial reason to be, supportive of this. So from my standpoint, I think it's a large corporation, it wants to show that it's supporting the community. And from that standpoint, I think, combining with what Craig mentioned about, you don't need a light. I think I agree with that from that perspective. But given that this is a large corporation, they want to promote how they want to present themselves in the community. I would be supportive of, having that sign, but, with the condition that you kind of have it over time, that it shuts off. Because if it doesn't really add value from going out and, bringing in customers at past 5:30 or 6, there's no value from that perspective. But from a branding perspective, it does add value to the corporation. So I would be, cognizant of that. Have the sign, use it till a reasonable hour and shut it if that's the concern that comes up. So.
I think I agree with Craig, and I'm wondering, could we split this application, because I'd love to approve the front, not the rear. I used to do retail leasing for Citibank for many, many years. I've been in your place. But a lot of times we didn't get approved with exactly what we wanted, and we had to go back and redo it. And I kind of, to your point, Chandra, I hear you. But it also, we have to preserve, the nature of our downtown. And I think in a lot of cases, it's a different issue, but I think we need to have some uniformity and some, for an upscale, it should look like the community.
I don't think it's standard. Like the standard has an elevated sign painted on the building, has an elegance to it.
Mm-hmm.
I think this is where this falls apart. Any other thoughts?
I was going to say I agree with all of you, but Craig, I think you hit it more on the head. I love what you've done with the front. It's really creative. I think it's wonderful. The back reminds me a little bit about those eyeglasses signs in The Great Gatsby. It's just still the big illuminating thing, so it kind of draws your attention, maybe not in a positive way. So I would be in favor of splitting the application if that's possible, if the applicant would be considerate of that.
Yeah, look,
Chairman, can we have 1 second to talk to my client to see if we can find some middle ground?
Absolutely.
Okay, we appreciate that. We're just going to step to the back.
Sure.
Thank you, appreciate it. No, it's late.
Thank
See if we can come up with something.
Yeah.
Make a motion.
Second. All those in favor?
Aye.
Aye.
It's obviously an important element, so we appreciate it. We can hear from Mr. Warner on what he thinks perhaps can make sense for the board. strike that balance.
We appreciate your comments, and we do want to work with the town. We're part of the community. We want to stay here. And we do want this to be branded as a Charles Schwab building. What if we were to reduce the size of the sign to a 6x6 and as well as lowering it, like you were mentioning, kind of centered on that ridge line? There you go.
The location's
Yeah.
no problem, and 6x6, that brings it down to the whole thing 36. That's from 64 right now.
And we could as well put it on a timer to make sure it shuts off at, let's say, 11 o'clock or something like that, so it's not on 24/7 the entire night.
What would be conforming? The height?
Well,
Not
it's above,
Okay.
we have a technical legal argument that we're not above the first floor because there's no real floors there, but we need relief, so.
Well, graphics, the graphics are limited to 24 inches.
You can paint that white too, which is gonna make it really stand out much more than the brick is right now. I wish there was something else you could do than that blue square.
Yeah, like I mentioned, it is our main priority as our trademark logo. It really is a priority to get that on the exterior of all our buildings.
Does it need to be illuminated at night?
It's our strong preference for it to be illuminated at night.
But it's not about wayfinding or architectural, whatever the lighting, right? It's about branding.
It's about branding the building, mainly, yes. I mean,
How many people are gonna see it at night, really? I mean, it's Milburn after, I can see at 6 o'clock, people might be driving home from work but like at 7, 8 o'clock, how many people are even gonna see the sign?
I agree with you
It's in
there.
the
I mean, I
back
think,
of the
in the
building.
winter at 6 o'clock when people are driving home, it'll be pretty visible.
Right, but I think sort of after rush hour, I can't really think you're getting much bang for your buck from the logo perspective.
What
or
time
any
can you
perspective.
live with Mr. Bronner? The board is.
I mean, look, those people that live back there on Taylor, like, they're not used to seeing illuminated business signs. I mean, they're just not there. I mean, yeah, you have it on the swim place, but that's a lot more lower down and not really a bright blue sign. Actually, they have no sign, but they don't even have one. But they have a banner, but it's not even illuminated. But anyway, this is definitely not, what I would expect to see in this area.
And we appreciate it, but it is a tenant that is taken.
Well, tenant exists now, so this is just they're just shifting down the street. Let's not oversell it.
I'm asking you to appreciate, and I know you do, that they're taking a big building in town, and the owner has done really a fabulous job. And our C2.
And we're not denying that.
Right. But with the criteria, we're asking you to take a look at the whole package. And I appreciate the board's perspective. They want to pick each individual element apart, and we're saying that I think that it's appropriate to consider the whole. Right, the beauty of the front gets weighed against some element of impact. You're suggesting you don't like it. It has some negative impact on the back,
but you can't have your cake and eat it too here. You can have elegant in the back too.
Well, we would like to have all elements of the cake. I'm asking you to consider.
I don't like lemon in the cake.
Don't you have that?
You appreciate what I'm saying.
Don't you have the Schwab logo in the front?
It's a pretty small window
blade,
sign in the front. Yeah, it's pretty small.
More people are going to see that than are going to see the back. I think.
Yeah,
But
because that's a pretty residential street there, right, after hours?
the
Front is gorgeous. We're just talking about that little. that
I'm
large
not talking
little
about
building
the
in
sign
front.
up front. I'm saying you've already got, if from a corporate perspective, they want branding.
Yeah.
They want their blue logo. They have their blue logo.
Is the major issue? Can I ask a question? Sorry, I don't know. Is the major issue the illumination of the sign? Is that the?
I think the height for me and the illumination. I just think bringing it down on the windows would be more elegant and sort of the way in the front. I mean, I could have opted in the front to stick it on the top of the building, much like Citizens game. But no, you kept it classy and put it over this, over the overhang that looks really interesting. And blade design's really, really nice. And then this, we get back to, old school square box illuminated.
So, I was kind of getting at, that's our logo. We can't change the size, the orientation of it. That is what it is. And I've heard that a lot of times from landlords and jurisdictions alike that it looks like a box sign, but it's actually built like a channel letter sign. It's built similar to the way, if they were individual letters, it's a square, and we can't get around that because that's our logo. What if I proposed a non-illuminated 8x8 sign, and then moved it down centered like Rich sketched on the paper?
Yeah, where is it?
I'm sorry.
So we have it like-
So it's hard to see. It would be centered on this line.
Right.
Illuminated.
It would still,
If we go with non-illuminated, if we go non-illuminated 8x8, I think we'd be okay.
Just to be, I just want to ask you a question of council. We can still say no because they still need relief, right? Because I mean, they're negotiating, but
Well,
it's
it's
still
all right.
out
We're playing a
of,
little
it's still not
Quid pro
conforming.
quo here.
I'm trying to.
Okay.
I mean, my interest is piqued.
My proposal is non-illuminated, brought down 6x6. That's my.
My concern is always the
16.
legibility of this sign because the letters are a lot smaller than the overall square, but I understand.
Well, I would support, if Jessica supports that, I would support it. That would be 4 votes.
Which Ashley's.
Ashley.
Yeah.
Yeah.
Whoever, at 10, at 11 o'clock at night, yeah, her, right.
I'll sit here till midnight negotiate this. Let's go. Any other thoughts on the board?
I like Ashley's.
Yeah, I can live with that.
Can you?
We can live with that.
Okay.
All right, then I'll close the public portion of the meeting. Do I have a motion in this case?
Move approval with the conditions that it's 6x6, it's non-illuminated, and it's brought down, how do you say that, to
The center of that room, like
Centered
you
on the
proposed.
center of, yeah.
Center of like the upper
Yeah.
parapet.
Yes.
What exhibit is that, Rich? So,
That's,
It wasn't labeled.
This was submitted.
that would now be,
Submitted, yeah.
that
It's
would now
the
be.
4th page of 5
Yes.
submitted.
See,
Okay, as
70,
shown on
66.
and as approved by the zoning officer in the resolution.
Can I have a second?
Second.
Anthony Abington?
Yes.
Barbara Barbani?
Yes.
Amy Lawrence? Yeah. Gary Rosen?
Yes.
Judy Truitt?
Yes.
Jennifer Glad?
Yes.
Yes. Good luck with the sign.
Appreciate your time. Thank you for staying with us on that.
Motion to adjourn?
Oh. Anyone in the audience have any discuss what's on the agenda this evening? Let me know. There's nobody here. Motion to adjourn?
Second.
Yes.
All in favor?
All in favor.
Aye.
Thank you. Still got almost 15 minutes back.